The one motion and distribution.
Yes.
Well, can I give him 150 or combined list mallet? Can he have upgradation? Because my
Please hand over the slip indicating the urgency. Yes, call the list.
Item number one.
well, I am from the petitioner.
Yes.
Well, I am for the respondent with my learned junior.
I am for the statement.
Yes.
But the petitioner is seeking the direction upon for the demolition of the illegal constructions which are constructed on the highways.
Yes.
So you kindly come to page number 17.
17.
17. This is my representation, which is required to be considered by the authority.
My lord, now the district magistrate is the authority, my lord, according to 26F. That is against the national highway. So my lord, direction was given to that.
Maybe given
He
to
must
you, I
file
have
an application.
Two, I
before
think. What is the section?
26 to
26.
26
26
the
2.
26F, my lord.
if
26F.
Yes,
So, where is that act? Control of.
national, no, national highway.
national highways.
Hmm.
So this is
So, is it under National Highways?
Authority.
দেখি একটুখানি National Highways একটা দিন তো। এখানে আছে।
you know, license can be issued under section 25. There are 26 and then 27. And Lordship,
Control of. No, this is.
Traffic and control.
Lordship, it is National Highways Land and Traffic Act
That is what I am
2002.
saying. Land and not National Highways Act. That is
In
what I am saying.
paragraph number
Control of
12.
National Highways Land and Traffic Act.
Traffic act.
Yes.
So 26(2) is the relevant
Yes,
provision,
madam.
which provides for removal of
Encroachments
unauthorized occupation.
includes
and-
construction.
Yes, construction. And Mr. Dev, which provision you have said that by virtue of which the district magistrate?
My lord, now, my lord, on the
Yes,
previous
there is a
occasion, my lord,
notification.
I have given one notification before
There's
your
a-
lordship.
Do you have a copy of the notification?
My lord, your lordship, I know, my lord, that is the, there is a, my lord, amendment was there and notification also is there.
একটা notification আছে ওইগুলো একটু রেখে দেবেন তো একটা
Sir,
ফাইলে নাহলে
Notification roll
And
লাগাই।
my lord,
now it's the district magistrate.
now district magistrate,
So, but
Well,
Mr.
file an
Chatterjee, have you
application.
submitted any representation before the district magistrate?
no, my lord.
District Magistrate, my lord, yes, I have.
No, to be abstaining.
This one I have given the copy.
Copy the.
The executive, no, you have given the copy.
Yes.
So copy is there. So I'm directing him
Yeah.
to annex a copy of this representation also. I'm directing the district magistrate to consider.
Yes, my lord.
No, DM has not been given a copy.
Yes, yes. Copy 2 has been, he's not,
Taking in that.
one of the, I think page 22.
Yes.
22 is there, my lord, that was reached, my lord.
Mr. Chatterjee, 22 is the comprehensive
Yes, my
representation.
lord. 22, 21 onwards is
So 21, I'm directing 21 to be
to be
considered.
considered disposed of, my lord, in the stipulated.
21, I'm directing the district magistrate to
My
consider.
lord, my lord.
Petition Mr. Chatterjee, have you implemented the private respondents?
Well, we don't know the private respondents.
You don't know. You are a public spirited person of the locality. You
There are
do not know
shop rooms.
who is encroaching.
There are many shop rooms, my lord.
You do not know.
We
Then that is not maintainable. You are not a public spirited person of that locality. If you say you do not know who are the occupants,
occupants, lordship, we don't know who are there, who are owning the shop.
then you do not reside in that locality. Any encroachment upon the highway, person residing at that locality does not know who are the occupants.
Well, I
It's
will-
very difficult to digest that submission, Mr. Chatterjee.
it's very- Yes, ma'am. So they will give.
But I am Milord.
Yes, Mr. Chaturvedi, what is this matter?
বালি
But I
বিক্রি
am
করতে পারে না কেন 5
I'm
মাস চায় এত?
Accept.
বালি বিক্রি করতে পারে না এক বালি নিয়ে 3 বার এক্সটেনশন।
Milord, I appear for the petitioner. Milord, lease Milord has been granted to me. Milord, permit Milord for Milord transportation was also issued. Milord, the tenure of the permit expired. Milord, a penalty of over 1 crore rupees was imposed.
1 crore.
My lord,
He paid that. That is not disputed.
Yes, paid.
I paid that. Milord, extension was granted for 1 month. My case is
Not
that
one.
I was granted, I could mine Milord, 12 lakh cubic feet of sand, out of which I could not dispose about 10 lakh cubic feet. But it was extended for 1 month. Lord, that tenure has expired. Lord, I have made representation
For further extension.
for further extension in view of the fact that it was an improbability. I could only
What has been done on that
on
representation?
that, Milord, this has been forwarded, Lord, by the ADM.
Rejected.
No,
Then,
forwarded by the ADM to the MTDCL,
yes, because they are the authority now.
my lord. So, Milord, that Milord has to be considered, Milord,
Let
along
them
with
consider, let them take a decision on this.
my
Now, Lordship, may I just indicate one thing? In the mining plan, your Lordship knows that his lease is still valid. Lease is valid till 2027. In every year, in the environment clearance, there is stipulation of quantity which the petitioner has to achieve. That is a minimum limit, maximum limit. Now, in 2024, it is the usual practice because in the monsoon period, the mining operation remains suspended.
It has been forwarded to you with the authority. I'm not directing you to allow, but
Lordship.
you have to communicate your decision.
Lordship, Lordship.
He must know what is the fate of his representation. Either you
Yeah.
reject or you allow. You have to
Sir,
take a
আমাকে copy-টা
decision on
দিন।
that. Pending approval for extension, it has been forwarded to you on 18th of December 2025. Today we are in February.
page
It's
1.
between ADM and you.
Yes. Lordship, kindly stay within
Sort it
15
out
days.
with Mr. Galib.
Within 15 days, it will be.
Sort it out with
Disposed
Mr.
of.
Galib. It's between you and Mr. Galib. Where is your representation, Mr. Chaturvedi?
Milord, page 126.
তাহলে হাতে দিচ্ছে না। ও না, এটা this is addressed to ADM তো 127 বললেন।
No,
126
126
the
was
representative.
It was addressed to the ADM.
ADM has forwarded it
Yes,
to you.
yes.
That's the subsequent. Mr. Chaturvedi, please give him that document.
Yes, I have received.
So ADM has now forwarded it to you. So you take a decision on that
Lordship.
according to the relevant provisions. The petitioner Yes.
I am for the state. The land of the father of the petitioner was acquired. Compensation has been paid. Subsequently, a notice has been issued to the petitioner for issuance of land loser certificate. They have a direct.
Been issued to the petitioner.
Yes.
Where is
Page
that?
18. Page 18.
1/8.
1/8. They were directing the petitioner to appear for hearing. Petitioner
Yes.
duly appeared. But
Yes.
till date, no certificate has been issued. Petitioner made
Yes,
representation.
what
Next
happened?
page 19.
They have submitted representation on page 19, P4, on my 1st of July 2025. Can you direct the litigation collector to consider this representation? Whether they are entitled or not, we will take
Please
decision.
communicate your decision.
Yes, yes. Only. So whether on the basis of this page 18, whether any decision has been taken or not, that instruction I do not have now. Only direct the litigation collector to consider this representation.
So this is with regard to direct purchase.
Direct purchase.
You have not received the compensation.
I have received compensation.
Then why hearing?
Hearing for issuance
Oh,
of
issue certificate,
certificate.
exempted category.
Exempted category certificate.
The petitioner states
Your Lordship, I appear for the petitioner. my lord.
Yes.
Affidavit of service is here, my lord.
Yes.
My lord, very innocuous prayer, my lord. Certain entries which in fact the
Record of rights.
There's a correction of record, Honorable. Not maintained.
Lord, just one document I want to show to your lordship.
Please show it before the tribunal.
No, not one document, my lord. May I just show one document, my lord? For my lord, I had made one representation. Pursuant to that representation, my lord, a local inspection was carried out. Lord, kindly comes to page 32, my lord.
32.
32.
Yes.
Last two paragraphs, my lord.
Yes.
As per the inquiry report of RI, it is clear that the applicants Anchar Gain and others exclusively possess over LR plot number such and such and have never been used for public purpose at any point of time. Now, my lord, in the Banglar Bhumi, this thing, lord, it has been written as for public use. My name is there, but has been used. Now, taking advantage of this, my lord, certain people were trying to encroach. So we made that representation.
To correct the record of rights.
Just that. But in
Inaction of an authority, please approach the tribunal.
no, my lord, may I just also in that case, my lord, I have made the police authorities a party over here. My lord, till the time I get
Inaction of police inaction does not fall.
no, my lord,
to-
till the my lord, kindly helps me, my lord.
That is your prayer. You have to move on the group 9 by a separate petition.
My
Uh,
lord, kindly
No, sir. Thank you. Yes, the petitioner.
there is no
Aspect-
dispute.
Yes,
My lord, I am for the petitioner.
yes.
My lord, this petition has been filed against the inaction and non-action of the part of the, my lord, appellate authority, statutory appellate authority, my lord, for necessary direction upon the statutory authority to dispose of the, my lord,
10-4 appeal.
pending appeal. Yes, my lord.
10-4.
Yes, my lord, kindly, what happened, my lord? My lord, kindly see page, my lord, 33. My lord, it is HDO's order,
That was challenge.
and
Uh,
HDO,
Order is, who is the appellant in 10-4?
my
You
lord,
are the appellant.
this is district magistrate.
Who is the
Appellant.
appellant in the appeal?
Appellant, my lord, encroachers. Encroachers
Why have you
appellant.
not implemented the encroachers as parties?
My lord, encroachers, my lord, my prayer is, my lord, to dispose of the appeal. My lord, upon hearing the respective parties, including the appellant, my lord, kindly prayer, it is innocuous prayer, my lord. My lord, kindly see the prayer,
The
first prayer.
to expedite the process without impeding the encroachers.
No, my lord, neither of the party will be prejudiced because, my
They
lord,
are entitled to a hearing. They are not entitled to a
my lord,
hearing.
it is proved that they are the encroachers. It is
They do not have any right. What are you saying, sir? That's the basic thing. Encroachers have a right to be heard. The
I am for the stay. And, a report was filed on the last day. Your lordship was not satisfied because not the report did not disclose whether the particular land of the petitioner has been utilized or not. Because proposal of direct purchase is there, 198 plots are there, but the report didn't disclose not that part. Now, your lordship directed not to take instruction regarding utilization. But what we have received not is that it's a portion of a larger plot. They have to do survey to not ascertain whether that particular plot has been utilized or not. They need some time. They have requested for some time to do the survey and specific.
With the bill order.
They have asked for 4 weeks.
6 weeks বলেছে।
No, 6 weeks.
Asked for 6 weeks.
4 weeks. They have asked for 6 weeks.
Yeah, for 6 weeks my
After
lord.
that,
But bill order is required my lord in this matter my lord.
they will have to demarcate.
You have got more than, we have got how much time? 28th of January, the order was passed. So,
Yeah.
My lord,
4 weeks.
4 weeks.
6 weeks my lord.
5th of March, Ashun.
In item number 7,
Nine, my lord, Mr. Kamal Misra is appearing for the petitioner, my lord. Mr. Misra is on the number
Yes,
11,
yes.
my lord. Kindly short pass over, my lord.
Yes, what is this matter? Yes, Mr. Bandyopadhyay.
Well, we have received, my lord, the BLR report. There is an encroachment.
There's an encroachment.
Yes, lord.
Yes, who is for the private respondent?
I am for the private respondent.
Yes,
Private, item number 8, my lord.
in item number 8. No, 6, who is appearing? You are appearing.
It is my lord 7.
Sorry, 7.
7 I am appearing, my lord. Now, so far, my lord, the private respondent is concerned, my lord, already an demolition order was passed in connection with, my lord, the another writ petition, and that was challenged before your lordship, and the same has been, my lord, set aside by your lordship. This is my lord order, kindly see.
Yes, on what ground it was set aside?
My lord, on the ground of violation of principle of natural justice, my lord.
Now there is no violation.
No. My lord,
Violation.
may I say, my lord, may I say?
Now
My
that
lord, there is only order. There is only one order, and the private respondent here, my lord, were the, my lord,
Now the
petitioner.
order will be passed. Now its demarcation has been made. This process will start.
No, demarcation was made. Your lordship
That has
given
been set
liberty to.
aside.
Yes.
That has been set aside.
Yes.
You have got relief. So it cannot be said that you will continue there. So that is why I directed a fresh inquiry.
Yes.
So now you are, you have the copy. Yes, Mr. Bandyopadhyay, please give a copy of the report to him. Yes, please see whether the report is, you have got the copy of the report. I will record that you have got a copy of the report.
আমি আরেকটা কপি আছে করে দিন ও দেখতে চাইছিলেন
এত ভুটোভাটি করছো কেন? দেবো কপি, একটু অপেক্ষা করো।
Yes, this is my lord report.
You have got a copy of the report?
No,
Now let them proceed accordingly.
my lord, may I be my lord my lord, I want to my lord file objection to this
Do
report
that before the authorities, not here.
before the authority.
Do whatever you want before the authorities.
My lord.
Please, Mr. Bandhavada, please give a copy of the report. Demarcation. Oh, you have given?
Yes,
দিয়েছো তো মাইলট?
এখন দিলাম একটা কপি দিলাম
কেস নম্বরটা বলো।
এটা
14393 রিপোর্টের কপিটা মাইলটকে দিতে হবে কি?
একটা কপি অরিজিনালটা
সেইটা মাইলট দেখুন তবে তো।
একটাই কপি ছিল কিন্তু হচ্ছে
Where is the inquiry report of the RI?
there is no inquiry report of RI.
That has not been Millard.
Bandhavada, how this
That is
demarcation
not
was
Millard
made?
enclosed here. Millard.
Where is that?
Malord, that
How have we ascertained the encroachment? Is this the way to ascertain encroachment?
My lord, may I submit, my lord? Only one inquiry was conducted.
Please wait.
Yes,
দাঁড়াও।
yes, my lord.
আরআই
Millard,
রিপোর্ট
next page, Millard,
Yes.
the report of the BLL, Millard.
Yes.
তারপরটা আরআই
দাঁড়াও, মাইলটকে দেখ। ফাদার নাম্বারিং করুনি কেন? ভেরি ব্যাড।
Mr. Bandhavadhyay, is this the way to make an inquiry of demarcation encroachment?
RI report Millard appears, Millard, last page, Millard.
Yes. Is this the way how an encroachment is ascertained?
As per the direction of the BLRO, the undersigned inquired and demarcated such and such.
Inquiry, he will go visit there and say, yes, there is encroachment.
During
Is
it
it the
appears.
way?
Millard.
So, Bandhavadhyay, you are delaying, you are creating complications.
Millard.
Look at the wastage.
Millard. It is Millard rightly. You rightly pointed out, your lordship.
Whether any, have you taken instructions, whether any demarcation
Millard,
survey
I
that
shall
was made
take,
or
Millard.
this is the
Some
only
time to be
document?
given, Millard, 1 week, Millard, I shall take.
If not done, please
Instruction
do
এরা
that.
কিভাবে এনকোয়ারি করেছে এটা ঠিক হয়নি।
আমি তো ওটাই শুরু পাঠিয়ে তারপর কাজ
না এটা
করাই
কথা না। এটা ঠিক হয়নি। কিভাবে এনকোয়ারি করলো, কিভাবে মাপলো,
What is 9? Who is in 9?
9, I am for the petitioner, my lord.
9, you are for the petitioner.
Private respondent, sorry.
Private respondent. Same thing, Mr. Bandhavadhyay, you are appearing in 9 also.
Millard. Mr. For is there, I am also Millard.
Same type of report.
Same type of report.
তাহলে ওই একই
সেম টাইপ
একই সঙ্গেই তো আছে।
Milord, I appear for RVNL. Milord, Lordship implicated me as a party, Milord. On the ground, Milord, the allegation of the petitioners is that the RVNL and Metro Railways are shifting the stations, my lord. My lord, my humble submission is this from, my lord, since 2012, the planning is going on, coordination between different departments, lot of money has gone down the, my lord, from the exchequer, my lord, and 50% work is done. Now, my lord, only thing, my lord, that there was no change of plan, no change of shifting at all. Right from the beginning, 2012 till date, my lord, there was no shifting. And my lord, learned friend's prayer is, my lord, that since there is a shifting, my lord, that it should be considered.
Yes.
My lord, kindly.
File a report with regard to this.
Lordship, I'll file a report.
The learned
My lord, I appear under the state respondent. My lord, I'll be requesting, my lord, praying before Lordship, kindly give some time. I will file a report, my lord.
Yes, what is this matter?
Illegal encroachment, my lord, alleged.
Illegal encroachment, the construction carried on in the PW road. My lord, just in front of the petitioner.
I will take
They
it.
are
For the state,
Lordship, my lord.
just in front of the plot.
take steps, hold an inquiry. If
Yes.
there is encroachment, take steps in accordance with law.
Or your Lordship kindly,
And for the private respondent number 12.
my lord, or your Lordship kindly direct me, my lord, to file a report to that effect. Whether
Because before filing the report, you have to conduct an inquiry, demarcation, to find out whether there is any encroachment or not. Do that. I am directing you to hold inquiry. If there is
the
encroachment,
representation that they will represent in terms representation made by them, and it would be disposed of after Miller taking steps in accordance with law.
yes. What is your
My
stand?
lord, there is an allegation regarding encroachment of riot land, my lord.
Yes.
Yes.
Yes, riot plan. Kindly see.
My lord, kindly
Just
come to
front
page,
of the priority plot of the petitioner. It was
page 25.
carried on.
My lord, kindly
25, yes.
Page,
annexure 3.
page 26 also, my lord.
My lord, kindly
This is the, my lord,
Have-
advocate's letter, demand justice
request
notice.
for necessary steps for holding an inquiry in respect of plot number such and such situated at Mauja until jail number 72 Bagnan Howrah illegally and forcibly encroach upon my by the accused person.
My lord, by page 26, my lord, advocate's letter, kindly your lordship reads, my lord.
Illegally and forcibly encroach my client's land.
My lord, kindly sees
And
page
my lord-
20. একটু বলে নি ভাই।
Yes.
My respectful submission. The portion of the encroach, that is not the allegation. Allegation of the paragraph 4 I stated. My lord, the just front of the petitioner's royalty plot, the plot number such and such.
No. Paragraph 3 you have stated forcibly encroached upon my client's right.
Rayati plots, my lord, page 26.
So at
So
the
far,
same time,
Yes.
my lord, my respectful submission.
You file a fresh representation because if it is allegation that encroachment upon your property, it's paragraph 3. You file a fresh representation, I will direct them to consent, not this representation.
That lordship teacher. That is
The uh, if it is service taken on record. Yes, call the next matter. Yes.
12, my lord, I am appearing, my lord, to last occasion, your lordship direct, my lord.
Yes,
Me to appear in this matter, my lord.
Yes. You have
For the
got
state.
instructions, Mr. Vishwas?
My lord, I have got the instruction, my lord.
Yes, what is this matter? Yes, sir, what is this matter?
My lord, the land appertaining to block number 2978 was originally owned by one Aditya Prasad Rai. Quantum of land is 9.79 acres.
Yes.
Ancestors of the
Illegal recording in the record of rights. How can that dispute
no,
be
my lord,
decided?
that is not my only prayer.
That's your prayer A.
Please, prayer A, not demolition. Kindly have a look. Prayer A.
So prayer A cannot be granted.
Kindly let me first, then I am coming to that.
The prayer A is barred. That is why I'm saying.
And kindly have a look. Prayer B.
I'm on prayer A. Prayer A is barred. That is what I'm
Illegal
saying.
recording of the name of the petitioner.
That cannot be granted in a writ petition.
My lord, Priori, I am not pressing that one.
You are not pressing.
My lord.
The learned advocate appearing for
Lordship will also find done.
vested land.
Yes. Vested.
What is your plot? 2978.
2978,
Yes.
4 point total quantum of land
Please,
is
please, please. So 2978 is the RS plot number. Total was 9.78 acres.
9.7 out of 9.
Total plot was 9.79. Yes.
Petitioner's land was never vested to the state.
You are in possession of how much now?
More than 6 bighas vacant land.
But this report says out of 9.79, 9.79 acres was vested land.
9.79 was total quantum of land. And out of that, 50% was vested to the state.
Yes, 4.89.
4.89 was
And ITI
Rest portion
Santuri
of the
got
land.
4.41 out of this vested plot and is situated on 4.41. Santuri Rural Hospital is less than 2 acres. But even that, if you do so, Mr. Bishwa, that is in excess of 4.89. Oh no, this hospital is a gifted property.
Hospital.
My lord,
is on the
he is
gifted
saying.
So it's a gifted
My lord,
property.
he is saying, my lord. My lord, he has not annexed,
I
my
don't
lord.
have any objection in regard to the hospital.
He has not even annexed
So
the, my
your
lord, the-
allegation is with regard to ITI.
ITI.
But ITI, as this report says, it's within the vested property,
My lord,
half area.
let them file a report on that on oath. They
My lord,
say.
my lord, not only
Till
that,
today, the land has not been demarcated. Till today, quantum of land has not been assessed. Till today, nothing has been assessed as regards to what quantum of
Sir,
land.
this is a vesting order. Vesting order, if you are challenging, you have to go before the tribunal.
Till today, no copy has been
You
seen.
know, you yourself is saying that 50% is vested. You know that. If you are agreed by that, you have to challenge that. That cannot be done in a writ petition. According to him, 50%, you are also admitting that the 50% is the vested land.
Kindly have a look to the.
You are not challenging that. 50% is the vested.
50% of the land that was the originally owned by Aditya Prasad. Why should I challenge?
That is why I'm saying, and this ITI has been set up on that vested land.
Let them say on oath.
no, this is not the, my lord, yesterday the ITI was not set up.
When the ITI was set up?
ITI was set up in the land of the petitioners.
When? On which day?
2011-12.
What were you doing for so long?
The number of representation was made.
Representation, if an illegal construction is made on your property for 12 years, more than 12 years, you will sit tight.
Construction started in the year 12, 13, 14.
So you allowed the construction to come up.
Raised
After it has been it has come up. Now you have approached the court.
Raised objection before the machinery. But kindly have a look to the ones.
Representation is with regard to the land dispute. It sort it out there. With regard to this construction, after such a delay.
One notification.
How have you explained the delay? Please show me how have you explained the delay when you come to know that this was.
One after another representation was made.
Representations do not cure the limitations, sir.
No,
you are aware of those line of decisions. So what were you doing for 12 years? You allowed the building to come up.
Kindly have a look with 10 years. Page 41.
Yes.
For my satisfaction.
Yes, 41.
This is a notice issued by the Revenue Inspector Rajaswa Adhikari.
Yes.
On 16th of January 2013.
Yes.
যেহেতু প্রতীয়মান হইতেছে যে নিম্ন তপশিল বর্ণিত দাগে আপনাদের স্বার্থ সংশ্লিষ্ট আছে, সেহেতু এত দ্বারা অবগত করানো যাইতেছে যে ইংরেজি 17th January 2013 বেলা 10টার সময় সরজমিনে ITI ও রায়তি সত্ত্বের জমি সীমানা নির্ধারণ ও চিহ্নিতকরণের কাজ করা হইবে. Admitted fact.
Yes, so that was done.
That was not done.
That you cannot challenge that in 2026.
Kindly next.
You cannot challenge that in 2026, sir.
Kindly have a look to the next page.
Yes.
Representation.
Yes.
On 2014.
Yes.
And another notice, page 43.
This notice you have received. So according to you, if that was not done, you allowed that to.
Page 43, my lord, kindly have a look.
Sir, please. It's a delay. The petitioner alleges that coming after 5 minutes. Yes.
That's the last occasion I have submitted that in terms of the order of the Honorable High Court,
Yes.
the executive engineer passed a reason order. Now, Lordship, first of all, my grounds was taken that on the date of inspection, no notice was served. Now, not only that, before the date of hearing, the inquiry report, the alleged inquiry report prepared by the concerned revenue officer also has not been supplied to the petitioner. Now, lots of the petitioner's reasons for not participating in the inquiry and no notice was served because petitioner at the relevant point of time was not in this residence, he was in abroad. Now, lots of in spite of that, the executive engineer has pleased to observe the notice was duly served. So, your lordship directed
Yes, Mr. Bandyopadhyay, have you got instructions?
No, my lord, we have not registered. But it appears from this, my lord, the PLR or the order sheet itself,
instruction.
the notice has been issued. He was absent, my lord. He was absent at the time of demarcation. Notice was duly issued.
So, have you given a copy of the report?
Well, that instruction.
The report
The
prior
81.
to, lordship, the hearing has not been given. Within the hearing, after the
Which order you are challenging? Please show me the
While they have stated that it has not been served upon him.
115.
113 starts. Relevant is 115. Lordship, kindly come page 114. At the time of hearing, petitioner stated that he is not Lordship buttressing the claim regarding obstructing him, his family members in progress of the national highway.
Is there any appeal provision against this?
No,
No, there's not. Understood.
because this is
There is not.
no.
This is under the National Highway Control and Traffic Act.
Yes,
26.
26.
Against the order of demolition, Lordship, there is a provision of it.
Against the order of
Demolition.
there is a provision. So here what has been done?
Yes, my application for demolition has been rejected.
Oh, you applied for demolition.
Yes, that has been rejected.
Kindly see, yes.
ভালো দেখছেন তো এত ব্যস্ত কেন
Kindly come section 26.
Please give me a minute.
Petitioner that he did not get the notice of demarcation. Just before it became evident the notice they had was issued by the block.
Where is the appeal provision? Which section says?
আমার কাছে বই নেই বই আনো নি কেন বই তো আনলে ভালো তোর বই আছে
আচ্ছা সবই দুটো বই আছে একটা দুটো বই আছে
বইটা কোথায়
টাকা দাও না
কত বই দিয়েছে
অ্যাপিল নেই অ্যাপিল নেই দেখেছি
Where is the appeal provision?
অ্যাপিল নেই
Before the highest authority of the civil court, there is a forum of, I have also in one case I have prepared
Decision made on appeal under this act by the tribunal.
ট্যাবলার মিনস যে আমাদের লোয়ার কোর্টে যেতে হবে
না না সেটা কথা নয় দর্শক যেটা খুঁজতে চাইছেন সেটা দেখতে হবে
তারপরে তো অ্যাপিল গুলো একটু কাজ কেমন না কথাটা
Where is the provision for appeal?
দেখছো
26 দেখছি
লাভ দিকে লাভ দিকে
Jurisdiction section 14, I think.
14.
Establishment of tribunals. The airport appellate tribunal established under the Airport Act and something. Shall exercise powers and conferred by it under this act. The central government shall specify. So this section 26.
So these are the old books. Subsequently 21 or 22 Lordship, this has been amended that there is a provision of appeal. So all both the books are
When it was amended?
Lordship, perhaps after 2020.
After 2020. This is 2021 book.
Kindly come.
আমার কাছে দেখতে পাচ্ছি না
No, this is finality shall be final and Shall not be.
Okay, right to appellant.
40.
Take assistant or legal.
Right to appellant to take.
The 43, the 40.
Every order passed or decision made on appeal. So any order is an appellable order. It does not say only the order of demolition. It says any order. Section 41.
41. 41.
Section 41 is the finality of orders.
Yes,
So any order passed is an appeal. Appeal lies. You can. These are all facts, Mr. Mukherjee. Whether notice was served, whether notice was not served.
Prove that is absolutely violation of natural justice. As on that date, I was in Dubai, Arab. I have proved this.
So what can be done? So they have served the notice. If you are not there, no, you cannot say you will be out of station and you will say no notice was served. You can say I was not present. Notice was. Please give me an opportunity. You cannot say notice was not served. You was served at your place of residence. You are not found. You went away.
Kindly say page 140.
Petitioner.
Yes.
That is how can, because I was not there at the relevant point of time in India. This is their observation absolutely contrary to the record.
Prefer an appeal, take all these points. These are all factual parts.
This is absolutely why not?
No, it's not
when
violation of
it has been supplied. Kindly see.
Mr. Bandyopadhyay, where is the copy of the inquiry report?
My lord, I have not received any instruction, my lord.
Please take instructions and
My lord.
take it.
But it appears from this, my lord.
Mr. Bandyopadhyay, learned advocate appearing for the state. Yes.
Leave may be granted to wait on.
My lord. It is not maintainable, my lord. How is affected, my lord?
Not today, I shall engage anyone.
I'm releasing this. Yes, call the fixed matter.
Milord, I am appearing for the petitioners. Milord, I am led by Mr. Aniruddha Chatterjee, Land Senior Report.
Yes.
Milord, I'm sorry, Milord, I'm a little outside court, Milord. Kindly extends the interim order, Milord, which your lordship had
No,
already
Mr. Chatterjee,
passed.
please make submissions. Please, I will hear
Milord,
this.
this will then keeps it at 2, Milord. I'll come back. I'll come to court at 2 then.
Please start.
Milord, difficult for me, Milord. The brief is not with me. Very difficult.
Mr. Chatterjee, every day this is being mentioned for taking up.
No,
Yesterday,
this is because the interim order was still, Milord, today.
main
And
matter-
Monday is the need fee.
Mr. Chatterjee, there was no interim order passed at any point of time.
Milord, there was an understanding with Mr.
Yes.
Chaturvedi.
So only there was an understanding.
Yes,
Yesterday it was mentioned for being taken up yesterday itself.
That is because the matter is fixed on Monday, Milord. Because we have to file our written statements if we don't,
Mr.
Milord, get
Chatterjee,
that
that is why
understanding.
I fixed it at 12 noon today.
Milord, keeps it at 2, Milord. I'll come to court at 2. I'll be there at 2. I'll do the matter. I have no problems.
Have your junior notified the other side?
My lord, I did. I have.
They are not. None of them are here.
Once again, I am informing. I have yesterday's.
Have you informed them prior to mentioning?
Through email, after mentioning also. Prior to mentioning, yes, my lord, I have.
Please show me the notice.
Ms. Devopriya Ghosh is appearing for the opposite parties. She is the learned advocate on record. Yesterday evening also I had sent a notice.
Bring them 2 p.m. Raku. Yes, 2 p.m. Yes, call the
I'll
list.
be there. I'll be there.
Inform the other side.
Number 15.
15. Out of when do you want?
26. ওই জন্য my lord,
You will come, my lord, on
26th. Then I'm keeping it in the monthly list because 26th is the last day. And
Item number 16.
My lord, in this matter, my lord, I am for the petitioner.
Yes.
My lord, your lordship.
In compliance, my lord, direction, I have half the copy, my lord, this affidavit of service.
yes.
My lord, kindly see your lordship's order dated 11th of November 2025.
Yes. What is this matter?
This is matter, my lord, my land has been utilized by constructing road, but I have not given any compensation.
Kindly see order, demarcation.
Yes. What is your instruction?
District Magistrate.
Who are you?
I'm Jila Police Officer. I have made partner.
District Magistrate. Who is appearing? Mr. Jyoti Prakash Chatterjee.
Jyoti Prakash Chatterjee is on legs, my lord. I'm praying for a day.
You are assisting him.
My lord.
Yes. What is your instruction?
Submitting the instruction, my lord, the form of an affidavit. এটা একটু দিয়ে দিন না
Copy দিন একটু।
একটু আমি নিজে কপি দিন স্যার এটা আমি এখনই দেখতে পাচ্ছি এটা নিজেই জানি
Yes. Have you got a copy of this report?
No, my lord.
Serve a copy. The
Nineteen.
My lord, affidavit of service kept on record.
yes, it is service technology.
19 হলো না?
Your lordship, in this matter, I'm for respondent number 3 to 5.
Kept on record for us.
Yes.
My lord, এটা একটু দেবেন জজসাহেবকে 17.
What is your instruction?
If your lordship kindly comes to page 7, please. Page 7, my lord. Here is the
Page
award
7 of
note.
the report.
My lord, page 7 of the report.
Yes.
Award of the note, it pertains to the entire jail number. Now your lordship kindly comes to page 1, the declaration. Page 1. In connection with my lord, LA case number 6, 2017-18, this pertains to the declaration, my lord, where the Girija Devi has admitted, আমি ধার্যকৃত সোয়াংশ টাকা প্রযুক্তিগত হস্তান্তরের মাধ্যমে সরাসরি আমার নামীয় ব্যাংক অ্যাকাউন্টে গ্রহণ করিতে ইচ্ছুক, and her PAN number, account number has been provided.
Yes.
Now your lordship kindly comes to
paid that amount.
My lord, your lordship kindly comes to page, my lord, page page 6 of the report, page 6. This is, my lord, the entry in the award list. Number 8 is the petitioner.
Girija Devi.
My lord. Page it, which has been received, my lord, by some Mukherjee on 26/12/2023. And now your lordship kindly comes to page 9 and page 10. My lord,
Yes.
number 6, Girija Devi, total amount 32 lakhs. And my lord, the next page, credited to bank account number so and so.
Yes.
Total of Girija Devi.
Yes.
So this is my.
Your Lordship. The first thing is, Your Lordship, the page 7, which my learned friend is showing, is an award calculation. It's not an award copy. Because under the 2013 Act, Your Lordship, it has to be a format. It's given there.
Please show me the Railways Act under
Yes,
which
Your
what provision has been. Please show me that. Because this was acquired. Railways Amendment Act 2008.
Yes, Your Lordship. Your Lordship has got a copy of that. Your Lordship, determination of amount payable as compensation. Section 20F.
Yes. Do you have a copy of the Act? No, Railways Act, I do not have.
One second, Your Lordship. I have only one copy, section, just I'm relevant subsection 8, Your Lordship, kindly. Section 20F, subsection 8, Your Lordship, describes what is supposed to be there in an award.
Yes.
What components has to be there, Your Lordship? The documents which have been handed over by my learned friend doesn't disclose that, Your Lordship. And as Your Lordship is aware, from 1st of January 2015, the 2013 Act.
14, not 15.
No, for this schedule for its date is 2015. The Act came into force on 1st January 2014.
Yes.
But as per Section 108, this
2015.
Yes, 1st January 2015. Yes. So this Act has got a proper format where the award has to be described, because the government says they have to take care of 10 deeds violation, the average has to be calculated. And apart from this, this is for the railway corridor, Your Lordship, freight corridor. If Your Lordship comes to my writ petition, I only annex one document, which is at page 85, Your Lordship.
Yes. Page 85.
Page 85 of my writ petition, Your Lordship.
Yes.
It says, approval of entitlement matrix for DFC project in accordance with New Land Acquisition Act.
85 is in which volume? Oh, yes. Approval of entitlement matrix. Yes.
Your Lordship, so this gives the entire details from page 87, how this calculation has to be made.
Yes.
What are the factors I'm entitlement, what I'm supposed to get, everything is explained in this. So this award is only a calculation, it doesn't reflect anything over there, Your Lordship. This matrix has to be followed by them while declaring an award.
Not if your lordship takes the.
This matrix has to be considered by the competent authority while determination of the award, Your Lordship. As far as I can see the calculation, Your Lordship.
The award list is in page 6 of my report, my lord.
আমি একটা কপি চাইছিলাম যেটা এই ম্যাট্রিক্স ফলো করে পুরো
ডিপার্টমেন্টে ভুল লিখতে।
Yes, what is the infirmity in this calculation? Please show me.
Your Lordship, that I have to kindly, if Your Lordship gives me
because everything, factored land value, value of tree, everything has been taken into
Your Lordship,
additional amount, total amount, everything has been calculated. What is the infirmity?
Initially, what I can find, Your Lordship, I'll just request Your Lordship to give me accommodation. I'll come with details. But initially, what I can found is, Your Lordship, as per the schedule 2, there is one component, Your Lordship.
Which component?
The component is that if they're taking my land, Your Lordship, they will give me an employment. If not, they will give me a compensation of 5 lakh rupees, Your Lordship. That has not been incorporated over here, Your Lordship.
Where is that? Please show me that.
Yes, Your Lordship. One second, Your Lordship. Your Lordship has got a copy of the 2013 Act, Your Lordship.
2013 Act? Yes, 2013 Act I have. Right, Fair Compensation Act কোথায় বলুন তো? Fair compensation. 2013 Act একটু দেখুন।
না, 5 লক্ষ টাকা একসঙ্গে দেওয়ার কথা আছে।
এটার জন্য কি করতে?
Yes.
এখানে
Yes, 2013 Act.
Yes, Your Lordship. Page 73, Your Lordship. Choice of amenity or employment. The appropriate, this is also part of it, Your Lordship.
No, which annexure?
So the schedule, Your Lordship, second schedule.
Second schedule.
It says section 31(1), 38(1), and 1053.
Second schedule, yes.
Yes, Your Lordship. It comes choice of annuity or employment.
Choice of.
Yes.
Yes.
Your Lordship. The appropriate government shall ensure that the affected families are provided with the following option. Where jobs are created through the project after providing suitable training and skill development, in the required field made provision for employment at a rate not lower than the minimum wages provided for any other law for the timing in force to at least one member per affected family in the project of arrange for a job in such project as may be required. Then it says one-time payment of 5 lakh rupees per affected family. So they have an option of giving that, Your Lordship. So that is also reflected in the matrix which I have given to Your Lordship. So I don't find that composition over here, Your Lordship, initially. And I will only pray Your Lordship to give me this week accommodation. I will come with the details, what are the other components supposed to be given as per this matrix.
You know, let him come up with a supplementary affidavit, my lord. I will also take necessary instructions
Yes, Your
pertaining to
Lordship.
that. ঠিক আছে, আমি ডিপার্টমেন্টে মানে উনি বলেছিলেন যে আরবিট্রেশনে যাবেন, এর অ্যাওয়ার্ডটা পেয়েছি কিনা, দ্যাট ওয়াজ দি লাস্ট অর্ডার।
No, but
There is the provision for arbitration.
No, arbitration না।
Your Lordship, only I'll
আছে তো একটা, আছে তো একটা provision.
provision.
I mean, there is a provision, my lord.
Arbitration.
My lord. Huh? 20F6 of the Railways Act, my lord.
subsection
20F6 of Railways Act, pertaining to which, my lord, your lordship has directed me to ascertain whether she has received or got the award or not.
It's Your Lordship, but the award has to be in a proper format, Your Lordship, and all the components which are
That can be challenged before the
no,
arbitration.
Your Lordship. I'll satisfy Your Lordship.
There is a forum of arbitrator.
Absolutely.
Your Lordship.
Only for that, your lordship has.
Facts, it can be decided.
Your
My
Lordship,
lord.
it says if I'm not happy with the compensation.
So he is not happy with the compensation.
One second, Your Lordship. I'll submit before Your Lordship. There are,
if there is a forum, why shall I entertain?
Your Lordship, there are
Only because of that the last order was passed.
multiple judgments from this coordinate bench. Kindly give me an opportunity, Your Lordship. If I cannot satisfy, Your Lordship will pass an order.
Come to 20F6.
I have seen, Your Lordship.
So
but before
if you are aggrieved by that, if the amount determined by the competent authority under subsection 1 or as the case may be is not acceptable to either of the parties, the amount shall on the application of determined by the arbitrator to be appointed.
Yes, Your Lordship.
That is his bone of contention.
No, if they are not happy with the amount of compensation, here is not the fact, Your Lordship.
Then?
They have not followed the statute which is supposed to be followed.
So
by
that
determining the
pertains to
award.
compensation.
It has to be determined under the act, Your Lordship.
That
As
pertains to the
all
compensation
the
itself.
matrix, kindly give me an opportunity, Your Lordship. I'll come with a better particular, Your Lordship. If I cannot satisfy Your Lordship, I'll rest my case.
This matter is unnecessarily being dragged on.
It's not unnecessary drag, Your Lordship.
Because on the last occasion, submission was made on behalf of the petitioner also that they are ready and willing to approach the arbitrator.
No, Your
But
Lordship.
they were not
Your
aware
Lordship.
whether the award has been served or not.
I have never made any such submission, Your Lordship.
Pertaining to which the last order was passed.
Because there is a multiple judgment of the coordinate bench will submit before Your Lordship.
Anyway,
that the award has to be in compliance with the proper procedure. One component which I can see on the prima facie is that they have not added that. Rest, kindly give me an opportunity next week. Any day I will come with a better particulars. Because I have received it today only. So some accommodation may be given, Your Lordship.
Your Lordship, a copy of the report may be served to on us also. We are representing the DFCCIL. If that can be instructed from your end.
জুনিয়র কই তুমি আছো
না 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 ও আমার সাথে
তাহলে কাকে সার্ভ করবো
সেটা আমি জানি না। ওটা প্রজেক্টে হয়ে গেছে
আচ্ছা
যে প্রজেক্টটা করছে তোমার
ও তাহলে ওর ভিতরটা
কে আছে আমি জুনিয়র কেন
ছাড় ল্যাপটপ কি 36 কত হচ্ছে 236
পরের গুলোতে করা আছে নতুন স্ট্যাটিউটরি একটাই আছে
So according to you, you are entitled to compensation along with employment, along with that
No, Your Lordship,
settlement, everything.
as the law says, they are supposed
What
to
does
give
the law provide?
that
You
either
will be
they will-
getting compensation as computed under this act. You will be getting employment,
under
you will be
the
getting a constructed house, you will be getting an alternative land, all.
No, Your Lordship.
What's the law?
The schedule one says I will get the compensation as per the market value, Your Lordship. The law says they have to give calculate minimum 10 deeds. The average will be calculated and they will because that is not reflected how they have brought this calculation. They have brought
That's one thing.
That's one part.
one part.
The second part says, Your Lordship, as per the
A
schedule.
displaced person, he is entitled to award of compensation as per 2013 Act.
Yes, Your Lordship.
So he is
Regarding the
entitled to an alternative land.
No, in case of second schedule, Your Lordship, as per the act, there are two options. Either they will give me an employment if it's generated over there. If not, one-time compensation of 5 lakhs will be given. For me, there are certain particulars as well. Suppose I have to, if a business is being run over there, they have to give all the cost of shifting the business, not land for land. That is in Schedule 3, Your Lordship. I'm not entitled to Schedule 3.
What was the property which was acquired?
That there was a garage over there. Your Lordship. A building was there, and then a commercial garage was being run by taking license from the railway authority. So now that has been stopped because of this, Your Lordship. So that
value of structure has been determined, my lord.
Yes, Your Lordship.
No.
I'm not saying anything on that. The value of the structure will be determined, but there is no whisper about the transformation of the commercial part because I was running a business over there, so they have not reflected if that has been taken account.
The case made out in the writ petition.
Yes, Your
Is it your case that this alternative thing has not been?
My case is, Your Lordship, the award till now, they as after Your Lordship award.
Have you disclosed that you have received this amount?
Yes. And on protest that I have disclosed, Your Lordship.
That you have disclosed.
That I have disclosed. They have not given me any award copies. I was not aware what was the amount. That is my first
copy
case.
is not
The second case is that once they have to declare the award, they have to follow the act of.
Show me that pleadings in with regard to this
Yes, Your Lordship.
other part.
If Your Lordship kindly see para 5.
Para 5 of
page 7, para 5.
Of the writ petition.
Yes, Your Lordship. The pleadings. Your petitioner states that the authorities for construction of Eastern Dedicated Freight Corridor trying to take possession of the land of the applicant without allowing the applicant to pursue the said process of acquisition as required under the process of Railways Act 2008, as well as they're paying appropriate compensation to the applicant, which the applicant is legally eligible for without complying the provision of the laid down and the said act. So that is the Railway Act. along with the rate provision of the right to fair compensation, transparency, in Land Acquisition Rehabilitation Act 2013. It is submitted the petitioner had accepted the compensation with protest on the payment rule, but till date no steps has been taken in respect of said objection protest raised by the petitioner accepting said compensation. So with that has been done with the returns to the pool. Now, para 6. The petitioner still, as per the notification published by the Government of India, benefits of the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013 had also been extended to the land losers whose land has been acquired under Railways Act 1989, and thus the petition is placed before competent authority, that is the Government of West Bengal is the competent authority, to calculate the amount of compensation.
Who will give this land?
The calculation will be done by the competent authority.
Who will give this land, alternative structure, who will give?
That the competent authority will calculate, Your Lordship.
Now we have to calculate.
Which authority has to
So
give?
The railway has to give it, Your Lordship.
Yes. So,
Your Lordship, the law is settled that the competent authority, normally the land acquisition collector of the concerned district is the competent authority. He has to do all the calculation, recommend that to the railway authority, who is the acquiring body, who is the requiring body, and they will pay the compensation. As Your Lordship, it has fallen from Your Lordship that the arbitration. If I'm not satisfied with the compensation, definitely I can go for arbitration. But here the calculation is not made as per the law.
what for this compensation is paid?
For once for the acquisition of the land.
So, let us assume a hypothetical case, compensation is paid for that value. Then again, an alternative land he is entitled to since he has been displaced. So there was a construction made, so a constructed house will also be given. All things as per this, employment also to be given. Let us assume that he was running a business there, so an employment also to be given. Then why compensation? Is it not in excess of what you are losing? What's the object of this statute?
Your Lordship, that the statute has provided.
I'm asking you, there's a very recent decision on that. Where it says no, employment you cannot get both at the same time.
And Your Lordship,
considering 2013 Act.
Your Lordship,
Yes, consider that. Have not considered that judgment. Because otherwise, why compensation? You get that alternative land, don't take compensation.
Your Lordship, in this.
Because you are losing a property, for that you are being paid compensation. Yes, maybe some additional compensation and other things, but here it provides for land and other things. So we will getting compensation is for to compensate you for that loss. So you are getting that. You will be getting another land. You will be getting another house also if there was a construction. And if you have lost your employment, you will also be getting.
There's an alternative, Your Lordship. Either employment or they pay one type.
All these are in alternative, not simultaneously. Will not get. That was what I was trying to know from. Will not get everything as a whole. Otherwise, carries no meaning. There is a provision. You can say, yes, I have been displaced from here. Please give me, I don't want compensation. Please give me this. So you will be taking the compensation. You will be saying, give me that alternative land. You will be saying, I had a constructed area there. Please give me a construction there. I lost my employment. Please give me an employment.
Only
there.
one question
That's
I'm putting
not
it
the
to
scope of
myself.
this.
Was it not the duty of the company?
Milord, factor as Milord, it is there, Milord. Milord, it is there. Your Lordship kindly comes to page 4. It is categorically determined. Milord, the factor as land value, the value of the structure. Milord, everything is there. It has been.
If you want to go to the arbitration, I can give you. Otherwise, these aspects has to be decided on affidavits.
No, Your Lordship, I'm going for affidavit because my personal experience, Your Lordship, this the entire procedure, once there is a multiple order from this court where arbitration has been allowed, and for the last 1 year, there is nothing has been done.
That is the issue.
No, that is the issue. I'll satisfy Your Lordship on that point.
20F6 categorically explains about the
So
duty
those
of the
learned
arbitrator.
advocate appearing for the
This notification, Your Lordship, which is at page 85. This is the entire.
Because the entitlement matrix as per the.
Yes, sir. And it's the first, second, and third sheet, which Your Lordship has stated.
What are you entitled to? Please
I
specify
am
what are you
entitled to compensation, employment, or alternative compensation of 5 lakh rupees.
Under which point under schedule 2? Please
Yes, Your
specify
Lordship.
that.
Kindly, if Your Lordship comes to page 90, 4, choice of annuity or employment.
So only that, choice of annuity or employment.
Yes.
Any other aspect?
Yes, yes. I'm relying on
Page?
Page 890. Page 90 of my read petition, Your Lordship.
Page 90, yes.
Point number 4.
Yes, page 90 is the schedule has been. I'm
Yes.
looking at the schedule. Choice of annuity or employment. And what are the things?
That is point 4, Your Lordship.
Yes.
Then point 5. Point 6.
Semicolon. Subsistence grant for displaced families for a Please give your appearance.
Your Lordship, 17, 18, 19, 20, same matter. But I have
Yes.
worked in 17 only.
Mr. Ghosh, give him a
I am only in 17. That is the difficulty.
Your Lordship, I am for respondent number 3 to 5 in this matter.
Please give your appearance. You have got a copy. There also award has been declared. Amount has been passed. You are in 19. 19 ta same order kore din. Here also you are claiming under same heads.
Same heads.
19, same order. 18 is appearing.
18 I have got the petition.
Your Lordship, I am appealing for 17 to 20. Item number 17 to 20 in this matter.
Who is appearing in 18?
For the state, Your Lordship.
For the state.
For the state, देखिए 18 টা দিন তো ফাইলটা।
Order that ছিল। Your Lordship, Sukarna Datta appeared on the last occasion.
Sukarna Datta.
সুমন দে সিদ্ধার্থ ঘোষ।
এটা কোনটা এটা? আমি ওটা ইয়েতে আছি
19 আছে তো 18 থেকে আছে।
18 none appears for the state করে দিন। Let affidavit opposition এর সেম জিনিস। ওই অ্যাডভোকেট পিটিশনের অ্যাডভোকেট
কি হচ্ছে আমাদের রেকর্ড হচ্ছে না তো বাবা তুই দৌড়ে যা তো তুই আমার ছেড়ে চলে যা
তুমি যে বললে শোনা গেল তো
ও না প্লিজ গো
award has been declared তাহলে একই জিনিস আগেরটা 18 সেম 19 হয়ে গেছে 20 who is appearing 20 also same thing.
Your Lordship, I am appealing for
that I am appearing, but I don't have this brief. There is a confusion, my lord.
Happens, Mr. Ghosh.
Yes, Suman Sengupta. Suman Sengupta, my lord.
But here your name has been mentioned.
Order my lord, in the order, it has been wrongly written as Suman Ghosh. It will be Sengupta. So that is the confusion.
How many Sumons? That's the problem.
Yes.
Where is Mr. Sengupta?
Manaship, he's on his legs, Manaship.
His own award has been passed.
I'm not in the state panel, so I'm praying for time, Manaship.
তাহলে ওই এফিডেভিটের ডিরেকশনটা next call the next matter.
I'm giving that.
21 years. Have you taken your? Please take your book. Railways Act.
Yes.
এটা Railways Act নিয়ে নেবেন। এতে Who is for the stay? Who's for the petitioner? Yes, what is your report?
Report, my lord, and the center of the report, my lord. This mentioned plot, my lord, not involved in the LA case, my lord.
Plot is not involved.
Involved, my lord. It's a question of the compensation that arise, my lord.
So, Bandhavata, what is the last sentence of last paragraph? Question of payment of compensation, if any, entirely lies upon the concerned department utilizing the land without any. Has it been utilized?
My lord.
That is what you have to say, whether it has been utilized or not. You have said no acquisition,
No acquisition was made, my lord.
Can you utilize without any acquisition? Then you have to pay compensation. Neither here nor there. What report you are saying? Last paragraph is very vague. It entirely lies upon the concerned department utilizing the land without any acquisition.
Then, my lord, report be collected from the my lord, concerned department, my lord. Who is the
You have to take instructions from that.
This special LA, my lord, is not available.
Which department has utilized?
I just this irrigation department, I think, my lord.
Irrigation department. You are appealing for the irrigation department.
Yes.
Executive Engineer, Irrigation and Waterways Directorate. The petitioner.
8.
Petitioner. This the report of the Special Land Acquisition Officer, 24 Pogona South, dated 4th of December 2025.
The similar report has been.
So, Bandhavata, you are in this matter, next matter.
No.
Can you inform Mr. Suman Sengupta? Can you ask him to come? The Soumitra Bandhavata is in this matter. It's in your room. Yes. What is the report? Where is the report? Where is he? প্রিয়ব্রত বটব্যাল, Please ask Mr. Bandyopadhyay to come. Yes, call the next matter.
Yes, I'm the petitioner, my lord. There are two parts in this writ petition. One is annulment. I am not pressing this. Another is.
One is?
Annulment of patta, because that I am not pressing before your lordship. The another is, my lord, demolition of unauthorized construction on the pond, which has been given to the private respondent number 8 and 9. There is no sanction plan. So far my knowledge goes, and on the pond, my lord, without any conversion, it cannot be. And that pond is 26, total 71 acre and 26 decimal.
Who is for the private
I
respondent?
am the owner of 76 decimal of land, and 76 decimal is government.
Yes. Yes.
And over the said pond, my lord, the construction has been made.
Yes, what is your instruction?
Instruction, Lordship, is partly correct. It is a pond. It is already proceedings is going on. Refer to the case to the ADM and District Land and Land Reforms Officer. But is may consider last line.
Yes, violation has been detected. I am directing them to take necessary steps. You challenge this. If you are aggrieved, you challenge this. That's you challenge this. They have initiated a proceedings. They will conclude that in accordance with law.
Yes.
The petitioner as per the law, whatever is there, they will do that. So I'm only recording that they have initiated a proceedings for violation that will be taken to its logical conclusion within a time limit in accordance with law.
He is also made present at the time of hearing.
You know everything. Your client knows everything. The petitioner Please give a copy of the report to both parties.
Both parties.
Yes. Yes.
হ্যাঁ লিখেছি কেপি
24 years. Yes.
কোনো acquisition তো নেই এখানে এই প্লটে।
Yes. You are for the petitioner.
I'm for the petitioner, my lord.
Yes.
My lord, my learned senior friend, my lord, they were supposed to file a report on the acquisition, my lord, within 2 weeks.
Yes. Who was asked to file?
My lord, all the respondents. All the respondents.
Have you got a copy?
No, no, my lord.
Please give a copy. Yes, what has been stated here?
My lord, here
Dispute.
My lord, the dispute is one of my plot of land.
My report, page.
You are Holdia Dock Complex. Yes.
My lord, the plot number 239, 190, the Holdia Management Surgery. Said plot surrounded by so occupation of so. My lord, Holdia Dock. Sketch plan, my lord, I have annexed. Surrounding the area, which paragraph 3. In order to utilize the surrounding area owned by the port fruitful purpose, it was requested to the collector benefit by letter to such and such to initiate a LA procedure. Notification thereafter issued on 29th November 2002. Declaration dated 2nd April 2003 for acquisition of the said plot were published in the Calcutta Gazette notification. Then special LO by later data requested the placement of the fund amounting to 4,35,000. Subsequently, special LO later dated such and such informed estimated cost to be such and such. Regarding methodology of the ascertaining the market.
The acquisition has not been completed.
no,
Then
Only this.
and possession has not been made over.
Then how can you construct?
No.
Why do you lordship can you see the last paragraph?
Yes.
The entire area is.
Maybe it's not your area.
Not area. Why I have.
Then how can you construct a boundary wall?
No, I have not.
Boundary walls have been constructed in spite of your lordship's order, my lord.
No.
During that time also, my client went personally with a server copy of this order to stop and to honor this order, my lord. But my lord, they have said, no, we have got no information from any of the department, and they are continuing.
I have
And my lord,
Mr. Mahato, what is your instruction?
My instruction says, my lord, if your lordship kindly come that section 6 has been issued.
Thereafter, no award.
No award, no possession has not been made over to the.
That land is very much required for the farm.
Maybe you may require it.
No, I have entire land has been acquired. Some pocket land, my lord, it's very much.
Pocket lands you cannot utilize.
No, that notification has been issued, my lord.
Notification does not give you right.
Amount is concerned, my lord, there is a dispute.
That's between you and the state. The petitioner is not concerned
I
with
have
that.
not constructed on his plot. I have not constructed.
So this property, which is your property according to you?
My lord,
Plot number.
Choktaroan Mouja, Holdia, my lord.
What is the disputed plot?
My lord,
43.
Yes, my lord.
The LR plot number 43.
So LR plot number 43, you cannot utilize. Mr. Jana, have you constructed any boundary wall on plot number 43?
My lord,
my own very
Mr. Mahato, please inquire and submit a report as to whether any
construction
has been made in plot number LR plot
Kindly
number 43.
specify in the order which plot, whether any construction on that plot has been made or not. I will come with you.
The representation also.
Kindly clarify that.
If
because
your
I
lord,
do not know which plot. Entire land has been
there
acquired.
are two of the petition, my lord.
Petition, but the basis of the case is the representation. Kindly go through the representation. Page 21. Start 20, page 21.
Plot number 239.
239, my lord.
Yes, plot number. That moreover, the road adjacent to the said land has been damaged by such construction work, and they are not paying any heed to the point that this property cannot be encroached, but within the boundary wall, it is a freehold property and not subject matter of any land acquisition, in spite of several verbal requests made to the officers, to the concerned department, and to the contractors are engaged in the work. They are still engaging in the construction work and thereby illegally acquiring the land in question. which is beyond the scope of any law and force of the time being.
Which land?
This is plot has been mentioned.
A plot has
That
been
plot
mentioned.
number 43 RS doc number 239.
Yes, plot has been mentioned.
Paragraph 1 it has been
And
stated.
now the concluding paragraph. In this circumstance, it is requested to yourself to take yourself. The process of acquisition has started very soon. How, my lord, he has come to the and to make proper demarcation to the said plot, which is the subject matter of the land of acquisition, and portion which is not the subject. My lord, this can be, my lord, considered.
My lord, that
Which is
so you file a report because
My lord,
their allegation is that
I have specifically said my report also in the paragraph 6,
yes,
last two lines.
yes.
The government raised, my lord, the cost of the acquisition of land. However, no reply from state government has been received.
You sort it out with the state.
that is another thing.
Recently, the matter regarding the acquisition of the land in question had not been proceeded with further, and the matter remains stalemated. So I have not done anything.
Let him inquire. Let him.
That is my instructions clear.
That may be your instruction. I am asking the state to. Is the best person to demarcate.
My lord, lastly, for the purpose of the construction which is still going on the boundary wall, they have totally damaged the road for my ingress and egress to my land.
No.
Totally it is damaged.
My lord, his prayer is only to construct the road. Kindly see the conclusion.
Construct the road.
Whose prayer?
In the representation.
Yes. To construct
to construct the road adjacent to the land of my client, which was damaged and broken by such construction work. Last concluding 3 or 4 lines.
And the portion which is not the subject, and also to construct the road adjacent to the land of the clients, which was damaged and broken by such construction.
Different issue.
No, that's a different issue, but it is to be seen whether this property has been encroached upon or not.
Right, my lord, perhaps my lord, like metro rail.
My lord,
maybe subject to correction.
Representation also does not disclose that it is under the acquisition or the my lord.
I have mentioned that it is under no acquisition, my lord.
Yes.
And these reports also say that proceeding was initiated, Mr. Mahab.
4-1 was initiated.
Yes.
But section 6 was.
Up to 6 it
Up
was
to
done.
6, but no
So
position has been
it
taken.
has not been done thereafter. So some sort of taking over of that property, some action was initiated. It was not followed up. Now it is to be ascertained what happened to that plot.
Yes.
The petitioner claims to be the joint owner.
in my family, my lord, may I come back on Monday,
date?
28th, my lord.
28?
If your lordship, my lord, yes,
You are for the,
for the petitioner.
who is for the respondent?
My lord, that I will inform in the meantime, my lord.
The
I will-
28 টা না 28 টা একটা order record করে নিন today. If you know who the
My lord, I
respondent,
will instruct my junior to inform.
this, your junior will be there.
My lord.
Ask him to appear. Again, to not today to mark করে রাখুন তারপর। This is an objection then.
Item 22, my lord, has passed over. But there's a fault on the part of my advocate on records clerk. There was a direction to, it was my learned senior friend was appointed by my lord. There was a direction to serve. Probably that was.
Item number?
22, my lord.
22.
22, my lord. I had called for a report.
Yes. What order did I pass?
My lord had called for a report and my lord had appointed my learned senior friend.
But you have not given me a copy.
A copy.
My lord, have
We,
we also
Then you have received.
sometime, my lord, to be given.
আচ্ছা এটাতে করে দিন
In item number 123, I'm led by Mr. Honorable Sir.
Yes.
This is that matter where the petitioners have filed section 5 and 8 application before the learned trial court. That was rejected, my lord. On appeal also, my lord, the appeal was rejected. Hence the civil revisional application. Your lordship on the previous occasion.
এটা arbitration and conciliation act দেখুন তো আছে কিনা হ্যাঁ yes start
Your lordship on the previous occasion had given that liberty to us to seek for.
yes now please start with the main matter. Yes.
মূল মামলাটা করবে হ্যাঁ তাই তো it appeared today.
You have not been notified. Yes, sir.
I informed the learned advocate.
Yesterday night, my lord, my learned advocate received an information that the matter
Sir,
would
you are
come.
mentioning this matter every day without notice.
Upon notice. Upon notice.
He says only yesterday night he was intimated. Please show it to Mr. Chaturvedi. I don't think he will deny that.
This is the notice I.
Please show it to Mr. Chaturvedi.
Today.
So today he served notice.
No, not today, prior to this.
Prior to this also I served, my lord, but.
No, yesterday night he served notice. I do not.
And evening at the afternoon at 4:14 I served.
Yes, yes, that is what I'm saying.
Yes.
This will require me lot some. Just second. কোনো অসুবিধা নেই. This will take me lot some time, my lord, for me, my lord, to prepare myself, only to brush up what I have prepared.
When Mr. Chatterjee starts, everything will come to your mind. Yes.
Mr. Chatterjee also doesn't want to start.
Please, sir. Yes. That is why I fixed this matter so that this matter can be taken up. That is why I fixed the time. It was 12 noon. Now, I thought you have seen the Ponjika, the time. You did not want it to start at 12.
I was outside. That's
So you did not want to start at 12. That is why I fixed at 2. Must be an auspicious time for your.
I was outside. Your lordship wanted to hear the matter, but that's why. Millard, can you take
Something on lighter note, Mr. Chatterjee.
Always like with me, Millard, I've never been serious in my life, and that is at times I'm taken in a different manner, but I never.
Yes.
Kindly takes up, Millard, if your lordship recollects what the matter was. Takes up the arbitration clause.
Page
57.
$57.
Yes. Just give me 1 minute.
Yes.
No. Lord,
yes, 57, there is an arbitration.
Okay, that is true. No, I was trying to find out the main problem. If your lordship sees, Willard, the main problem was 8.2. This suit which they have filed.
8.2 of arbitration act. Yes.
If your lordship remembers, this suit they had only filed for documents. Now, in that, Willard, we said, Willard, that there is an arbitration clause. And we filed in section 8, the dispute arose as to with whom is the main, Willard, with whom is the original. That was the dispute.
Original agreement.
Yes. Kindly turns to paragraph 14, page 14.
Of the
impugned order.
Of the impugned order. Page 14.
14.
Appellate order.
No, page 14
Appellate order.
Appellate order. Kindly have a look first at page 11.
Yes. Yes.
The suit founded on possession of original documents is a possessory and a restitutory claim fundamentally distinct from contractual interpretation of enforcement. Honorable Supreme Court precedent mandates referrals only when disputes arise out of or are connected with the contractual instrument containing the arbitration clause. Now kindly comes back to the arbitration clause.
57.
Yes, because the learned judge has interpreted that it's not, the dispute is not arbitrary. Trial court it originally produces. Trial court kindly turns to Millard. First, my application is at 35. Your Lordship first satisfies my.
Wanted to show the arbitration clause.
Your Lordship has already seen it.
Oh.
Your Lordship saw it, Millard. I presume because when I was going through the papers,
Yes,
Your
yes.
Lordship.
No, if you want to place anything, you
No,
can.
I'll come back to it. Kindly turns to 24. This is his plaint.
Yes.
Then I'll just show Your Lordship Millard doing snippets. Takes up paragraph 4 at 26.
Yes.
That the plaintiff firm made payment of advance or earnest money for purchasing the A schedule properties on the date of execution of the agreement, and the plaintiff firm was very keen to get the sale deed registered in the name of the firm. In the agreement dated 9th of November 2004, a time period or tenure was mentioned, but the said Shevals were not intentional to comply with the terms of the agreement and the plaintiff firm for enforcement of the agreement. File title sunset. The said suit was decreed in favor of the plaintiff firm, and after depositing the balance consideration, the sale deed being number such in the office of district sub-registrar was executed in favor of the plaintiff firm through court. Then turns over, my lord. These are, I don't think, relevant for my lord's consideration. Please, paragraph 8, just to show what is the paragraph 8. What is the ambit of the suit and the dispute involved, that though the plaintiff firm delivered the permissive possession in favor of the defendant number 1 company, but the defendant number 1, without assigning any reason whatsoever, abandoned and left the A scheduled property and withdrew their staff therefrom, and they did not make any endeavor for development of the A scheduled property. Due to the inaction on the part of the defendant number 1, the A scheduled property was gradually being converted into a jungle, and the plaintiff firm presently has to spend huge amount for protection and preservation. Turns over. Damages and everything, it's all put there. Then sees the suit. 32. For a degree of mandatory injunction against the defendants, directing them to return back the document to the plaintiff mentioned in the Schedule B hereon, and also prohibit them from claiming any right on the basis of the B schedule document. Then kindly see Schedule A is below the land has been described, and the document is a Schedule
B.
Original sale deed, original settlement.
Original sale deed is executed through court.
Yes. Yes. That is why I showed your lordship that paragraph. Yes. Settlement record, original sanction building. Now kindly see why I filed the section 5 and 35. Lordship has already seen below the arbitration clause there. Then my lord sees paragraph 8.
Yes.
The original development agreement dated such and such is lying with the plaintiff of this suit, and the plaintiff is called upon to produce the same at the time of hearing of this application. We had to get into that.
Notice to produce.
The petitioner has been in custody of a true photostat copy of the said development agreement containing seal and signature of the respective parties, and a duly attested copy of the said photostat copy of the development agreement. Then we said that there is an arbitration clause, and C's 9. Under the aforesaid facts and circumstances, it is submitted that it is a fit case, so the court should refer the parties to arbitration. The development agreements Photostat copy is at page 40. And my lord saw the arbitration clause at 57.
Yes.
Then kindly turns to the trial court's order at page 63.
Yes. Yes.
Plea of the defendant, my lord, I'm not reading the entire, but the first part is a little important. That's why I'm on page 63 there. Is instituted in violation of the above provisions of law before institution of the suit. The plaintiff is mandatorily required to submit all documents which are necessary to give effect to the cause of the suit. Reference is repeatedly made to a development agreement dated 7th of March 2012 between the parties herein. However, the plaintiff has deliberately withheld the original agreement from the purview of this court. This itself brings to a situation where the plaintiff must be refused the relief paid for. My lord, comes to the observations of this court. This is what the finding is. This is an application under Section 5 and 8 of the Arbitration and Conciliation Act. Section 8 provides that the party to arbitration needs to insinuate the judicial authority regarding the existence of arbitration clause before filing of the written statement, the existence of arbitration clause pertaining to the facts and circumstances arising out of the agreement or condition preceding to such agreement. The agreement referred to by the contesting parties itself with certain development work which was supposed to be undertaken by the development. All the differences arising out of the execution and proceeding of the work defense demands a referral to arbitration. The present cause of the plaintiff's case is founded upon the return of certain documents which were purportedly kept in the custody of the defendant during the course of such construction and which is allegedly submitted to be in their custody till date. It is the averment of the plaintiff that the defendant is not returning the said document in spite of repeated insistence, and hence this case. The present difference of non-return of document by one party to the other has nothing to do with the clauses of the agreement and their subsequent referral to arbitration. This is a separate cause. It is a cause of civil nature, where a party is aggrieved by non-return of document by the adversary. It is covered within the meaning of Section 9 of the Civil Procedure Code, and the relief in such cases pertain to mandatory injunctions. Without going into the merits, this court is of the view that the agreement containing the arbitration clause is not the subject matter of concern. In the present case, those certain documents handed over in the course of the said transaction and their return is under consideration. The validity and existence of the agreement dated such and such is subject of trial. This was the ground on which, my lord, nobody has challenged the validity of that agreement. My lord, this is on the ground on which Section 5 and 8, my lord, was disposed of by the trial. Appellate court is more interesting. And he turns to the appellate court and sees why, my lord, the appellate court, my lord, it's right at the end. Looks to, my lord, paragraph page 5.
Of the appellate court's judgment.
Yes. Prologue and factual backdrop. The factual matrix as emerges from the record is neither too novel nor too obscure. The respondent, this is only the beginning. The respondent plaintiff instituted a suit for mandatory injunction to secure the return of original documents enumerated in Schedule B of the claim, which were admittedly handed over to the appellant defendant during the pendency of a development agreement dated 7th of March 2012. That agreement contained an arbitration clause which now forms the cornerstone of the appellant's claim for reference under Section 8. The appellants invoking the arbitration clause filed an application under Section 8. Curiously and fatally, they failed to annex the arbitration agreement. This is where, my lord, on the last occasion, a lot of arguments were made, if your lordship recall, where we had said that if an agreement admittedly is not with me, it's with the other side. And how does a person produce that? May I ask this question to myself? And how does that become fatal, my lord, for hearing a Section 8 application? Admittedly, my lord, there is an arbitration clause. Admittedly, any dispute arising out of that agreement, my lord, has to be sent, my lord, to arbitration. Now, this clause, yesterday Justice Sarkar has held that, my lord, this clause, I was trying to make a submission that it's not, my lord, arbitrable, that this clause is a valid arbitration clause, and whether the disputes are arbitrable or not will need to be decided by the arbitrator.
No, which clause is the valid arbitration?
The clause which your lordship saw, my lord, under in page 47. 57.
Yes.
So that there is an arbitration
Clause, there is
clause,
no dispute.
there is no dispute.
Yes.
That, my lord, the original is with them, there is no dispute.
That I don't think they're admitted.
There is.
No, the previous paragraph of the same order.
My lord, it is.
Previous paragraph of the same
There is
order
no
which my learned friend
dispute that
placed.
The original is with them.
No.
Have they
On the
admitted
last
that?
occasion, my lord, Mr. Chaturvedi had told your lordship.
No.
My lord sent it for, my lord, mediation as well.
For mediation is for a different thing. Whether this can be sorted out, these documents, that's a different thing. But show me, Mr. Chatterjee, from the pleadings that they have admitted this. Because you can say it's your case. Admission means you have to show that they have admitted.
My lord, may I,
Mr. Chaturvedi also cannot say something
may
here.
I say something? Very well. I'll take that back.
Paragraph
I'll
5
take that.
Paragraph 5
So if there is some admission, you can show it.
or the judgment that you are using.
Of the judge. Very well.
যেটা
আমি তো পড়ালাম দাদা
না মানে ওই ডেট ওইখানে ওই স্টেটমেন্টটা দেখিয়ে দাও
No, case is that it's lying with the plaintiff. Do they also admit that?
The appellate court in paragraph
what I
5 which
had
my learned
said-
friend placed kindly sees
said was
that the appellate
this
court
has to
actually
be an
বলে
issue.
যশোর যেটা জানতে
That
চাইছে বলে দিই
You will getting your chance.
No, I am only saying that my lord's query is answered in the paragraph which my learned friend read. The date is noted on which date it was handed over to the defendant.
Where? Which paragraph? Which page?
Paragraph 5, page 5, appellate court's judgment.
Yes.
The respondent plaintiff instituted.
কোনটা দাদা?
Which were admittedly handed over.
কোথায়?
Which were admittedly handed over.
To the
appellant defendant during the pendency.
Now, who admitted that?
This is recorded. I am saying my lord is only trying to find out as to what is the factual
Who
position.
admitted that then? May I ask this question?
Now my learned friend is saying that I told before my lord that it is with me.
All right. Yes, Mr.
Only this much, my lord. So
Now,
that
if my learned senior friend wants to say that it's immediately handed over to the appellant defendant during the pendency of a development agreement dated 7th of March 2012, that agreement contained an arbitration clause which now forms the cornerstone. Now, I'll read it once more just to understand what the learned judge is trying to say. The factual matrix as emerges from the record is neither too novel nor too obscure. The respondent plaintiff instituted a suit for mandatory injunction to secure the return of original documents enumerated in Schedule B of the plaint, which were admittedly handed over to the appellant defendant. Now, I haven't even filed a written statement. Now, this is where I'm trying to understand. Then, during the pendency of a development agreement dated 7th of March 2012, that agreement contained an arbitration clause which now forms the cornerstone of the appellant's claim for reference under Section 8. Now, he dismisses on the ground that I didn't file the original. But my case is that the original is with them.
Yes.
What the arguments then were, my lord, that whether it is with me or him, that needs to be first decided. If, my lord, Section 8.2 becomes fatal to me, then the court will have to come to a finding with whom is the original one.
Yes.
So I made this submission, and to an extent, your lordship was, my lord, hearing the matter on that, is that whether it is with me or him, that is disputed. That is not somebody, I loosely said admittedly, But I said that basically it's disputed with whom it is. Now, if it is disputed that it's with him or with me, he doesn't say it's with me. He doesn't say that I have the original. But if I'm not mistaken, kindly have a look at it. Kindly have a look at the next line. The excuse offered is that the original agreement is in the possession of the respondent.
Which next sentence, which page?
Page 6 top.
Oh, page 6, yes. Yes.
Certified copy thereof as required under section 8(2) of the arbitration. The excuse offered is that the original agreement is in the possession of the respondent. But such defense, however colorfully painted, cannot withstand the scrutiny of law. Then if it is with him, Miller, I will have to prove it, and he takes advantage of that. It is bizarre.
Yes.
With a lot of respect to the learned judge and his English, this is the finding is bizarre. Then, but such defense, however colorfully painted, cannot withstand the scrutiny of law. Though appellants claim the document lies with the respondent, statutory rigor demands otherwise. A contention tested through the crucible of case law. So what the learned judge really wants is that if the document is with him, I go to his house, steal it, beg, borrow, steal. I beg, I ask him to borrow. He doesn't give me, so I steal. Miller, this is a fiction of law which the honorable judge, which the learned judge might not have realized. Then he dismisses on that. The crux of rejection. The appellants fail to attach the original arbitration agreement or a duly certified copy, a mandatory precondition under section 8(2) rendering. The statutory mandate 8(2) is given, Miller. Then, paragraph 10, the phrase shall not be entertained has been judicially entertained with the judgment given, which is not relevant here. Your Lordship need not trouble Lordship self with the entire, all the ones which are really on 8(2), and whether if I have in possession and I am not given, then that becomes again a curable defect, or whatever it is. Then 18 comes the finding. The appellants fail to produce either the original or a certified copy under 8(2), whether at filing or before learned trial court judgment. No cure was offered, nor did they seek leave to tender it at any stage. Their contention of impossibility due to respondent's custody does not relieve them of compliance. Nor is an application of civil procedure code or evidence acted upon to procure. Then Miller kindly turns to, I need not trouble my lord self, again a lot has been said. Paragraph 21. Thus, the defense that the original agreement lies with the other party does not absolve the appellant of the statutory requirement. The obligation to produce the original or certified copy lies on the party seeking the defense. And if such production is not feasible, it must pursue other remedies under law, but cannot expect exemption under 8(2). The appellants neither filed the original agreement. Milord, may I ask this question to myself? Any other, if I don't have the original, so the arbitration agreement becomes odious. If the learned judge is of that opinion, Milord, then with a lot of respect, it is not. Milord, something which is not in my possession, I can't, Milord, do anything but to, Milord, only ask them to produce the original, which has been asked. Even, Milord, if your Lordship sees the earlier paragraphs, we had said that it's not with us, and let them produce it. That also, Milord, wasn't looked in. So now the learned judge feels that if 8(2) cannot be complied with, the parties have to be relegated to a suit, which in my respectful submission, Milord, is not correct. Then, 22 is the same. Milord, then it comes to paragraph 24. The
Breaking point and limitation.
The suit instituted is one seeking mandatory injunction for return of documents which were allegedly retained by the defendants even after expiry of the development agreement. The plaintiff does not seek enforcement of the said agreement or adjudication of claims arising under its terms. The reliefs are confined to a civil right grounded in possessory, recovery, and restitution. Where arbitration is also a civil right. It's just a forum of adjudication. The present suit is for mandatory restoration, return of original documents framed upon property or bolement principle. The suit founded on possession of original documents is a possessory and restitutory claim fundamentally distinct from contractual interpretation of enforcement. Honorable Supreme Court precedent mandates referrals only when disputes arise out of or are connected with the contractual instrument containing the arbitration clause. A possessory action falls outside the ambit. This again, Millard, is in the Thompson's matter. Millard, this was, of course, on the commercial code side. Millard, Deepak Polymer held that if it's a simpliciter suit for eviction, then Millard, it's beyond the it's not a commercial dispute for the commercial courts too.
Unless the property is used for.
No, unless it says, Millard, that suppose a suit for eviction, simpliciter suit for eviction on the ground of expiry of lease. The property is used commercial. Deepak Polymers held that there is no dispute under section 2. So it's a simpliciter suit for eviction. So it's not a commercial dispute to be tried by the commercial. If there was some dispute relating to the agreement and there is another prayer for recovery of possession, it is a commercial suit.
So coupled with the prayer for
Yes,
recovery.
but this was overturned by, not overturned, this was deferred to by Justice Krishna Rao. Justice Shobhusha Chivacharji was that, and it was referred to the larger bench. The division bench has now put the ambit way beyond Ammalal Sarabhai as well. But I'm arguing that matter. I'm saying that that is a per incuriam judgment because it went beyond the reference, and none of the lawyers from the Deepak Polymers case was called on to argue. So the court did not get the Millard, the ideas from all sides. Right? There was just one part where Millard, all of them said that it's only the everything can be heard by the commercial, which is in direct conflict with Ambalal Sarabhai. Ambalal Sarabhai said that you have to restrict the ambit to the commercial. Then the courts will get burdened if you give everything to the commercial. So now the matter has again come up before Justice Boshak, and I'm trying to Millard, argue on that because Deepak Polymers was argued by me. That's why I was trying to say that we should have been heard even once before any judgment could have been passed. But they all heard, Millard, just one part of the story, or one part saying that everything can be heard by the commercial court, and the orders were passed without to that extent. Similarly here, Millard, if the ambit is to an extent which says that everything can be heard in arbitration. Earlier, Millard, even frauds were not sent to arbitration.
No.
Now the Supreme Court says even serious frauds can be sent to arbitration. So everything which is related to that document, Millard, needs to go to arbitration. And 8.2 comes in only when, Millard, I am in possession of that document, but I am not produced. Or if there is an allegation of fraud, or if there is an allegation that that document never existed, I can still understand. That's not there in the statute. That's not there in the statute. If your Lordship sees, proviso. This was what I was trying to argue before your Lordship. The proviso to 8.2, Millard, was not even considered in the lot of respect by the learned trial.
Yes.
This 8.2, Millard, in my respectful submission, the proviso 282, I don't see that with a lot of respect. I'm not sure if the learned judge has even referred to it. So it's not that, Lord, that my learned senior friend or I, both of us are remediless if the original document is with him. That the law says so. Then, Lord, the learned judge has again gone on to, Lord, the appellant argued that the dispute emanates from the development agreement and therefore falls within the arbitration clause. However, as rightly noted by the learned trial court, the relief sought by the respondent is mandatory injunction for return of original documents, a possessory claim arising under bailment clause. With a lot of respect to the learned judge, and not a claim for performance or the breach of the development. My lord, if your lordship reminds my lord felt about the arbitration clause at 57.
Yes.
In the event of any dispute or difference arises by and between the parties hereto, either concerning or touching upon any terms and conditions of the agreement or any obligation arising out of or under the same or any other matter arising out of or in any manner related there. So anything related to that agreement, my lord, was arbitrary. So the learned judge's my lord, observations that it is under bailment clause, it is not a breach of the agreement. I don't think, my lord, the learned judge has, in my respectful submission, looked into, my lord, even the arbitration clause. And then, my lord, paragraph 6, the appellants invoking the arbitration clause filed an application to section 8. Curiously and fatally, they failed to annex the original arbitration agreement. My lord, you should have seen that. I'm not sorry, my lord. Looks to, my lord, synthesized conclusion. I'm sorry, looks to paragraph 32. যদি কিছু হয়ে যাচ্ছে না আমাকে বলে দিস দাঁড়া ফ্যাক্টটা শেষ হোক Further, the development agreement dated 7th of March 32 being unregistered, no certified copy from any registering authority could ever be produced. The appellants have filed only a photocopy which lacks any certification. In the absence of the original and absent registration, no certified copy is possible, rendering the Section 8 application non-maintainable ab initio. So that it should have stopped there. Now, on this, my lord, your lordship would know, my lord, after NL Global, this becomes completely, my lord, redundant. After the 9 judges bench of NL Global, my lord, this becomes completely redundant. Whether, my lord, it is, in our case, my lord, it's not even relevant, but even if an arbitration agreement, and this was on arbitration, NL Global was on arbitration, the Supreme Court now is very clear. It topsy-turvy, my lord, with 5-7, but after the final judgment has come in, my lord, it's quite clear that it's only when at the time, my lord, it is put into, my lord, evidence. It's only then, my lord, that
That's what the original view of our court was, not on arbitration, but on the stamp act.
Justice Bhaskar Bhattacharya's judgment, Justice Shubhra Kamal Mukherjee's judgment.
Those were the parent views taken thereafter.
Absolutely.
Now,
Lord, if you lordship remembers, it was argued by Mr. Shubhra Kamal Mukherjee when his lordship was at the bar before Justice Bhaskar Bhattacharya.
Swapnadip Lahiri.
That was the judgment.
That was the first decision.
And Mr. Raichodi probably lost it, if I'm not mistaken. Mr. Raichodi was on the outside. So that was our original view.
Section says so.
Section says. So we were surprised when this came in, but be that as it may, it said initially SB Patel, SB Engineering said you can't look at it because it's not enough.
Even at section 11 stage.
Section 11 stage. You can't look at it.
So then a question arose, section 9, what would happen?
What would happen?
Interim stage.
So they said that you cannot. It can't be touched if it's not stamped. And which was ridiculous because till the time it gets impounded and comes back, the property would have gone. So whatever it is the Supreme Court to decide on that. So this becomes completely redundant. And then see synthesized conclusion. My lord is seeing.
No, please. Yes.
The Act aims to minimize judicial interference per the non-abstante clause in Section 5. However, when mandatory requisites such as Section 8(2) are not met, judicial refusal to entertain is compelled by statute. The appellants, though entrepreneurial, is invoking arbitration, fail to cross the peremptory threshold of Section 8(2). The trial court's rejection, therefore, follows both logic and law.
Basically, the finding of both the courts, more particularly the appellate court, is that cannot apply under Section 5(8)
without
the certified copy or the original. So, if it is not there, you pursue your remedies elsewhere, but not before that's the sum and substance of the.
Then paragraph 40, that's the last paragraph.
Yes.
The appellant application under 8(1) was never entertained in compliance with 8(2) and they made no attempt to cure during adjudication. Furthermore, the dispute does not lie within the arbitrable scope.
Twofold things. One is on merits also that it's not arbitrable. And another is on the issues of entertainability that without those two documents.
So my simple answer, my lord, first with respect to, my lord, entertainability, 8(2) proviso not even looked at by any of the one. With respect to merits, my lord, your lordship has seen what the arbitration clause is. Any manner related to that agreement has to go, my lord, to arbitration. So that also needed to be, my lord, at least referred to by the courts, considered by the courts, and then said that this is not arbitrable. Those are my respectful submissions. My lord, there is one judgment that my friend wants me to show your lordship. But
on what point?
On 11, Lord, on the point about whether the dispute is alive or not.
That is, if the development agreement is terminated, whether the same can be, those are well settled. If you want, the junior wants to refer to that, you can cite that decision.
In this matter, my lord, the statute.
Strategy, they have searched out the judgment. If you, because otherwise he will be getting that I have searched out. Yes.
But we were always taught, my lord, that if the statute is clear, you don't need.
The juniors will also feel encouraged because
definitely
they have searched out something.
Absolutely, certainly. But also to know, my lord, that when the statute is clear, because we are now, it's the general thing, if I may tell your lordship, is that we are becoming very judgment oriented. Nobody looks at the basic statute. Every time, my lord, somebody comes, somebody new, so even an intern, the first thing they will come and show is that this judgment is there.
Because nowadays it's very easy
online,
to search out the
very easy. You tell ChatGPT, they will give you 20 judgments. And they are happy with it.
And 19 is against you. If not 20.
My lord?
19 will be against you. If not 20.
The problem is, then they don't have the patience of going through those 19 judgments.
That is why I told you, you have found out 20, thinking to be in your favor. At least 19, maybe also 20.
When we first joined the profession, also here. When we first joined the profession, the first thing our seniors said, even our great-grand seniors, that you should go through the books. After going through the statute, if you go through the books by searching for one case, you might get a judgment for another case. But by that time, the computerized things had come up. Mr.
This also has some benefit.
Very. The problem is we need to understand the balance.
Yes.
If we can balance it, in the way, it's very helpful. But we need to balance it. Only one
saves
part.
Time.
Absolutely.
It saves time.
It's
and
better,
energy also to pick up those books, bring it down.
It's better for judges. better for judges. And somebody who's had some sort of experience in the profession, say about 7-8 years into the profession, fine. But once you're first into the profession, at that point of time, I don't think it should be encouraged. Once you gain that experience, you gain that simple knowledge which you need to gain so that you can come and open your mouth. That point of time, you should not encourage this ChatGPT.
You are a senior advocate now, Mr. Chatterjee. You have to train your juniors.
I'm a
in
very
that fashion.
senior
No,
advocate.
Mr. Chatterjee, this because you have to tell them.
I have in my short whatever phase I have, my lord, I have always said this, that get your আমরা বলি ভিতটা তৈরি করা। If you- fundamentals correct, thereafter everything becomes way easier. But moment you get into and say you want a building first, then it's very
Once you
difficult.
read the statute, something will come in your mind.
The
Then if you search the
interpretation-
judgments, you will be finding a judgment in the way you are thinking.
Absolutely. Absolutely. And
It's not the other way around.
it can be that you can get something else as well.
Yes, yes.
Something else.
In
It
addition, but
opens up a lot of
something you will
avenues.
be finding, you are thinking in a line. If you search, you will be getting judgments in that line.
Money. So our profession needs to go ahead, but the old things needs to be
Balance has to be.
a balance. And if there is a balance, the person will really thrive.
For that, both of you are there because
he more than me.
Both of you. So the juniors are to be taught in that.
Yeah,
So you have a duty, Mr. Chatterjee, Mr. Chaturvedi. both of you. Yes, Mr. Chaturvedi.
I don't know, my lord, how to oppose a man who says so nice things,
Man who says
such nice things. He almost took me into reminiscences. We used to, my lord, pick up the digest of each year and find out whether the issue that we are searching is available there or not. And in the process, yes, and in the process, maybe bring about 20 digests down, and yet at the end of the day could not find one.
single judgment.
And now it is available at the click. Word-wise search, word phrases search, section-wise search, topic search, party name search. My lord, you name a search and it is available. It is available. The other day, my lord, I was hearing Honorable the CGI, my lord, addressing a seminar. He said the balance between the mind and the machine. And then he emphasized that the mind must rule the machine. It should not get the other way around. So that balance between the mind and the machine and the mind ruling the machine should be important. And for the mind to rule the machine, you should first apply your mind to what is available and then let the machine begin doing its work.
Yes.
My lord, to have the facts clear, my lord, kindly comes to page 28.
Yes.
My lord, paragraph 8, my lord, the first part was placed by Mr. Chatterjee. My lord, kindly sees the second paragraph, the subparagraph to paragraph 8, that the defendant number company, after execution of the so-called
9, not the second part.
I'm sorry, my lord, 9 is.
I think
it's yes. Then
yes.
9 লেখা আছে তো আমারটা 9 বাদে the defendant number 1 company, after execution of the so-called development agreement, requested the plaintiff firm to hand over all the original title deeds, settlement records, municipal records, etc. on the ground that the original documents are required by the financial institutions for approval of housing project proposed upon the scheduled property. Then next line is important. The plaintiff firm handed over all such documents.
Yes.
To the then director, and the said documents are mentioned in Schedule B hereunder. And Lord, kindly comes to paragraph 31, page 31, paragraph 14. that the defendants are withholding Schedule B documents wrongfully and illegally, and in spite of demand for return of the documents by legal notice, the defendants are not complying with the same, and it is unnecessary to compel the defendants to return back the original documents mentioned in B, and as such, the plaintiff is compelled to file the instant suit. I maintain my suit on the basis of these two principal pleadings. And my lord kindly sees my principal prayer at page 32 for a decree of mandatory injunction against the defendant, directing them to return back the documents to the plaintiff mentioned B. Now, my lord kindly sees, my lord, what does the agreement say? My lord kindly comes to page 51.
Yes.
Lord kindly sees, Lord, Roman 9, owner's liabilities.
Roman 9 is
page 51.
yes.
Lord kindly sees, Lord, the subclause therein, Lord, subclause 5, the owner shall deliver or cause to be delivered.
Clause, subclause
5.
5, yes.
The owner shall deliver or cause to be delivered to the developer all the original title deeds relating to the said land simultaneously upon execution of these presents. Now, my lord, if, my lord, we can draw an analogy between, my lord, what is postulated in section 8 and, my lord, in respect of an provision which has an analogous effect on a proceeding, Lord, contained in Order 7, Rule 11. But the court, Lord, says that I would not take up your list. You need to go elsewhere, or 7 Rule 10, sorry. You need to go elsewhere. Not that the list per se is meritless. Lord, what is to be looked into?
So according to you, may not be one forum, maybe the other forum.
I say at that stage, Lord, what needs to be looked into? Because the defendant has not yet got a chance, Lord, to compete the claims of the plaintiff. So, on the basis of whatever is before the court, Lord, namely the plaint, Lord, the court is to decide. Now, what, my lord, I showed in paragraph 9 and paragraph 14, that along with the admitted document, this agreement is an admitted document. My lord, if seen, but the facts that, my lord, unequivocally, my lord, can be deciphered is that the document is with them. And the finding of the appellate court that you had the document, you did not produce it. I say, Lord, is it a finding? Lord, that perverse, which would shock your conscience that my lord would not interfere, because a statement from the bar is made that no, I do not have. What is it that the appellate court at that juncture, my lord, could have done in the absence of requisite steps having been taken by the defendant applicant of section 8?
So according to
there was no application. There was no application, blood, calling for production of the document by me.
as required under the proviso to.
I am grateful to my lord. Mr. Chatterjee knows it. Now, if I'm sorry.
Evidence that yes. Yes.
Now, if the notarized copy thereof is filed, Lord, I put a question to myself. Lord, as to the procedure, I come to the Act statute later. Lord, we all know that certification of a document to be true and correct, Lord, is a declaration that it has been compared with the original. If I, my lord, take this document to the notary and say, certify this to be true, my lord, he should not do it. I do not know what would he do. Lest we follow the convention, when I address my lord, I address the law. There may be notaries who may, with deepest of respect, may notarize it. But I say, what is the legal implication of a notarized document produced by a party? I say that he possesses the original, he takes a copy of it, he takes the original and the copy to the notary and seeks to compare the original with the copy and to certify the copy thereof to be the certified true copy.
He has produced the notarized copy of that.
He has produced, the kindly comes. His application.
So is this, he produced a notarized copy?
Yes. Kindly comes to page 39.
Oh, copy, true copy attested.
Notarial certificate.
So, Mr. Chatterjee, only one thing, Mr. Chatterjee Chaudhary, because there cannot be a dispute with regard to this. Along with the application, or maybe subsequent thereto and whatever, which document you have produced?
The notarial certificate, notarial.
So, original notarial document.
Yes. Yes.
So the development agreement containing the original seal of the notary has been submitted.
She's 39. এটা না জেনে বলবো যা রয়েছে সেটা দেখিয়ে দিচ্ছি
Yes, yes, yes. No, Mr. Chatterjee, my query to you is, no, I have seen that. My query to you is whether a photocopy of this or the original.
And I need to take instructions more. Without instructions, because from the records I don't see this anywhere.
No, but if you have produced the photocopy,
I believe
this original, I'm not saying the original development.
I understand that. I've understood.
So this original will be with you.
Should be.
Or you have produced that.
Because
either of these two.
Because if your lordship sees page 39, it is with the notarial certificate.
Yes, yes, I've seen that.
Certified Xerox copy of the original. I've seen that.
Yes, yes.
I did not produce the original before the notary. I produced the certified copy, Xerox copy.
No, what are you saying?
39.
Yes.
I produced the Xerox copy.
No, where is
Is that certified Xerox copy? So my learned senior friend's argument is probably not correct on that.
I do not get. Oh, certified Xerox copy.
As per the same. So I don't think I've produced the original before the notary.
No. I'm not saying that certified Xerox.
I have understood my lord's query.
Yes.
This is the answer to Mr. My learned senior friend's argument. That I must have had the original and produced it before the notary, who has seen the original and given a notarized one.
No, what is the meaning of this certified Xerox copy?
Because I didn't have the original, I took the Xerox copy to be notarized.
Xerox copy from the?
I have a copy of that agreement. A Xerox copy.
This is says certified Xerox copy as per the same.
Yes. Certified Xerox.
So Xerox were certified.
Exactly. He has not certified the original.
No. Certified Xerox copy as per the same. Where is that copy from which you have obtained this notarial certificate?
I have to produce. That now offhand I cannot.
Yes.
So that argument, Millard, is not correct, that I must have had the original and gone.
Yes, Mr. Chaudhary.
And I'm not sure, Millard, if there is an objection to section 5 and 8. I tried to find that out. If my learned senior friend can praise your lordship, if they had filed an objection to 5 and 8. Because I have not found from the record. If
Mr. Chaturvedi, whether any objection was filed to this application under 5A?
Because in the misappeal they had filed, but I have not filed
the not as per the original, not to the original application according to you. Yes.
I have an handicap today, my lord.
All right. Yes.
কি পরের দিন করবে? পরের দিন করবে?
No, 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 no.
না না না। তুমি কোথাও যাও?
Yes, yes,
না না যাওয়ার ছিল আমরা বলবো না।
yes.
Now, my lord, kindly, my lord, comes to page 24. I'm sorry, I'm sorry. Page. Page 35,
35, yes.
my lord.
Yes.
The date of filing of this application on the right-hand side top, my lord would very kindly find is 22nd.
22nd July 2023. Am I right? Yeah. Because this is the signature of the advocate.
What should be 22,
22.
if I'm not wrong. May I, my lord, only check? Because I proceed on the basis of 22. May I, my lord, check, my lord, how has the learned?
No, what are you trying to show from that?
Yes, my lord, from there, my lord, I say, but kindly see that this 22nd of July 2023, when 2022, when this application was filed,
Yes.
my lord, immediately before that, my lord, the document was got notarized, which is at page 39, which is on the 29th of June 2022. If my learned my lord, has my lord seen that these two dates, now be it my lord 22nd July 22 or 23 would not make much of a difference. I am showing page 35 and page 39 to say that page 39 is obtained sometimes on 29th of June 2022, and then the application is filed in July 22 or July 2023. Now the agreement is of 2012. If my learned friend, whatever my learned friend is saying, that what was given to him was a copy of this agreement, he never had that, the original with him, then my lord, the notarized document would be of 2012, 13, 14.
একটা জিনিস interrupt করে দিই দাদা। There was another submission which was being made that I had not prayed for my lord calling for the document. That is also incorrect. It's incorrect.
In the application, it is there. আমি দেখালাম
It
তো।
is there in the application itself.
Yes, yes.
So saying that I had not prayed for the document to be produced is incorrect.
No, no, it is not.
I have prayed for.
In the application, there is no separate. I was addressing.
You said that I had not prayed for.
Then I am being corrected.
He has not filed any application,
Yes.
separate application. That's what he says. And you will be submitting that you have couched in the same application you have stated.
Where is in the law that I have to file a separate?
Yes.
I have no objection in Mr. Chatterjee correcting me in piecemeal, because, my lord, we belong to the generation where we have been corrected in piecemeal. The moment we do commit a mistake, we were corrected then and there. There was no passing off. There was no passing off. Let him make something bigger. Then we are those parents who are committing that mistake.
Yes.
So,
Yes.
so if a notarized copy of this document was handed up to him, and that is what that he had, and that is what he could have annexed to the Section 8 application, then I would say that it would have been contemporaneously given to him upon execution of the agreement, whereby I, the owner, retain the original copy of it and give a notarized copy of the agreement to him. So it would be 7th March 2012. It would be March, April, May 2012. He would have had a copy of the document. But the document that he relies on, the agreement, is notarized in on 29th June 2022, and the application is filed immediately thereafter. So the probability that I, my lord, generate out of it is that he has the original. He did not want to part possession of it. He makes a copy of it, goes to the notary, and makes a notarized copy certified by the notary and annexes that with the application. Now, my lord, there are two things, my lord, which the court of first instance, my lord, was confronted with. One, my lord, the statements contained in paragraph 9 and 14 of my application. My lord, page 51, my lord, clause 9, subclause 5, which, my lord, give out that the original is with him. And the court is confronted with, my lord, his statement that the originals are not with him, he is producing a copy thereof. Now, based on this, my lord, and nothing more, because there is no other pleading with the court at that stage, the court was to decide as to whether the petitioner was, the applicant was making a correct averment before the court or not. Well, the court came to a finding. A court came to a finding that he was under an obligation to bring on record the original. Now, as many, my lord, in as many words, that reason or the logic, my lord, which today, my lord, I supply to the finding may not be there. But the conclusion is correct. So, on the anvil of non-compliance of the requirements, my lord, under section 8, my lord, the application was dismissed. Against that, my lord, he preferred an appeal. Well, the appellate court, my lord, rejected his appeal on twofold grounds. The added ground was, my lord, arbitrability, non-arbitrability of the dispute. But to address first the prime contention in this leg of argument, Mr. Chatterjee said that arbitrability has to be decided by the arbitrator.
He says it's an arbitrable dispute since it arises out of that development agreement, because according to him, it's a development agreement. Everything is connected with that. So it arises or in connection with that expression.
I shall correct my learned senior friend later, not immediately.
Yes.
Now, kindly see, my lord, what he was addressing to, my lord, may I? My lord, he was addressing, my lord, on page 10 of the appellate court's decision.
Yes.
My lord, he was addressing, my lord, on paragraph 25.
Yes.
My lord, which is under, my lord, head 8
Yes.
on the nature of suit and substance of the dispute, non-arbitrable claim. My lord, we say that this is not arbitrable.
Because the dispute in the suit, according to you, does not emanate from the arbitration agreement or terms of the arbitration, terms of the development agreement.
And I rely on section 9 of the Civil Procedure Code. My lord, Mr. Chatterjee, my lord, here, to begin with, he said that whether it is arbitrable or not, it was not for the court to look into it. My lord, he referred to, my lord, section 11 also. Now, but the consistent view of courts, my lord, are that the powers of the court in adjudicating section 8 and section 11 are a little different. While in section 11, my lord, what Mr. Chatterjee says, my lord, may be correct. But in so far as section 8 is concerned, my lord, I shall rely on a division bench judgment of our court. But the court said that in section 8, the court, there is no absolute bar in the court looking into the arbitrability of the dispute as well. So court has looked into it. Well, again, my lord, I come back to my original argument as to whether these finding or this, I say, this adventure of the court, in the words of Mr. Chatterjee, if it is a misadventure of the court, first appellate court, to look into the arbitrability, I say, I am saying an adventure. I say from his arguments, the word would be a misadventure. He did not say it. I am not saying so. But is it, my lord, one which would shock the conscience of the court? No, no, no. The court could not have done it. Because that is jurisdictional error. Then, my lord, in exercise of Article 227 would correct it. If he is acting within, my lord, his jurisdiction and determining the arbitrability of the dispute.
Whether in 227 a different view can be taken.
I am grateful to my চমৎকার junior Miller, she has in the meantime found out that we did file a written objection to section 5 and 8.
Please give a copy to Mr. Chatterjee. You have one copy.
Just one copy.
Please give me one. I am giving it to Mr. Chatterjee.
বল তাতে লাভ হলো না ক্ষতি হলো আমি জানি না বুঝতে পেরেছিস সেটা হলো
Yes, Mr. Chaturvedi, you are right, because that date ought to have been 2022, because your written objection was in December 2020.
And my lord, that, my lord, again fortifies, my lord, the analogy, my lord, which I am drawing.
Here it has been
Yes.
stated that the original agreement is in the custody of the defendant.
Yes. So
denied that, otherwise it would go uncontroverted. So yes, please give a copy.
Yes, yes, my lord, I shall.
Handwritten handwritten addition part, but with some with those signatures and other things.
Yes. Now, my lord, I recollect that, my lord, this was shown to my lord on the last occasion.
Dispute that this handwritten part is not there in the original.
Not there.
No, no, that he said it is not there.
We had taken instruction and come back and
No, no.
we had taken instruction and come.
Today, Mr. Chatterjee said that possibly Mr. Chaturvedi's client did not file any written objection. Lord, he said that, my lord. If memory has to fail, my lord, I say that it should fail first to me. Mr. Chatterjee is younger to me.
I don't have a problem. Calls for the record.
No, no, but you said that I did not file a written objection.
I had asked.
And now you say that.
I had asked you.
Mr. Chatterjee, for this little things, records did not be called for.
Because this
Both of both of you can take instructions.
Because I remember now, my lord, we had taken instruction.
Yes. Yes, Mr. Chatterjee.
Yes. Now, my lord, kindly sees, Lord, based on this, Lord, the learned trial court, Lord, I would only indicate a little part of it. At page 64,
Yes.
Lord, kindly sees the observations of this court. This is an application immediately after the two important considerations. This is an application under section 5 and 8 of the Arbitration and Conciliation Act. Section 8 provides that the party to arbitration needs to insinuate the judicial authority regarding existence of arbitration clause before filing the written statement. And then, my lord, kindly skip over the next two paragraphs. Next one paragraph, and then the paragraph starting with the words, the present cause of the plaintiff's case. The present cause of the plaintiff's case is founded upon return of certain documents which were purportedly kept in the custody of the defendant during the course of such construction, and which is allegedly submitted to be in their custody till date. It is the averment of plaintiff that the defendant is not returning the document in spite of repeated insistence, and hence this case. The present difference of non-return of document by one party to the other party has got nothing to do with the clauses of the agreement and their subsequent referral to this arbitration. My lord, I pause here for a moment. My lord, this finding, my lord, has been affirmed by the first appellate court. But I put a question to myself. Milord, in invoke,
Finding.
I am grateful to my Lord. The validity and existence of the agreement dated 7th March 2012 is subject of trial, which can be decided on merits upon adducing evidence. Ex facie, this application does not concern the above consideration. Not that he is remediless or out of court. Gauged in the above factual matrix, this court is of the view that the application under Section 5 and Section 8 of the arbitration clause is hereby rejected at this stage without any. Now, Lord, kindly sees, Lord, how but the first appellate court, Lord, deals with Lord, kindly comes to Lord, page 6, paragraph 10.
Page 6, paragraph 10 of?
Lord, the first appellate court's judgment. The phrase shall not be entertained has been judicially interpreted by the Honorable Supreme Court, held non-compliance to Section 8.2 renders the application jurisdictional infirm and liable to be dismissed. Then, but the next page, in Magma, echoed this clarity, emphasizing the object of Section 8. And then,
Mr. Chaturvedi, subject to correction by you, 2008 judgment may not be relevant because proviso was inserted thereafter.
no, I come to that. I come to that. But in so far as, Milord, the effect in the present facts, but the incorporation of the proviso also does not inure any benefit to Mr. Chatterjee. I would address my lord on that.
Yes.
While section, paragraph 12, the Honorable Supreme Court explained that while Section 8.2 bars entertainment at the time of consideration, mere non-filing at the stage of presentation does not automatically result
It's a curable defect.
But no steps were taken because the definite stand of the defendant is that I do not have the document in original with me. So both the courts, were only to test this fact on the basis of the available pleadings. If 7th March 2012 is an admitted document and the application under 5 and 8 is being filed in 2022 with a notarized copy of the document containing the seal and stamp of the notary of 2022, I put a question to myself, what would be the logical inference which can be drawn that this document, original whereof was executed in 2012, was secured 10 years thereafter by the defendant, although the project has been abandoned about 8 years back. The project was to be completed within a period of 72 months. Now, after 2 years, they did not take any steps. I asked them documents, they did not give me documents. So the project was abandoned then. I have started seeking the document from them. Was there any question of me handing over a certified copy, notarized certified copy on 29th June 2022? Because that is his case.
Yes.
Then, paragraph 13, the interpretation tempers the formalism of Atul Singh by acknowledging a window for cure before adjudication does not dilute the need to comply or when the application is decided.
So
I need not.
May not be relevant because curable part is a different thing altogether.
Has not done it.
Yes.
So the court, I am only saying, but the court has been kind to him.
That you can cure the defect.
That you could have. That means, my lord, I presume that even in course of, my lord, hearing of the appeal, possibly, my lord, the court had aired this view to the in court, and that the no steps were taken. Hence, my lord, the court.
Yoti defect.
Yes. Now, my lord, the stamping, my lord, is not quite relevant. My lord, page 10, my lord, Roman 8, paragraph 25.
Yes.
The suit instituted is one seeking mandatory injunction for return of documents which were allegedly retained by the defendant even after expiry of the development agreement. The plaintiff does not seek enforcement of the said agreement or adjudication of claims arising under its terms. Lord, I pause here for a moment. I am saying, give me that document. Lord, I put a question to myself. I am whether, Lord, referring to the text or the context of the agreement. The answer to that is no. I'm not saying that you are to give me this document because give me this document. You are not doing anything. Give me the document.
According to you, the dispute in the suit does not arise out of or are not connected with the development agreement.
I am asking the very document from which dispute or differences may arise. The reliefs are confined to a civil right grounded in possessory recovery and restitution. The present suit is for mandatory restoration and return of the original document framed. But this, my lord, is the concurrent finding, my lord, of fact on interpretation of section 9 and section 8. And which, my lord, I beseech, my lord, that in invocation of, my lord, Article 227, my lord would not. My lord,
anything more, Mr. Chaturvedi?
My lord, my lord, would only, lord, refer to a decision, one on the scope of, lord, section 11 and section 8, as to whether the first appellate court, my lord, committed any error which would shock my lord's conscience in interpreting.
Holding that it's not arbitrable.
Yes. In getting into the issue.
Yes. In holding that it's not arbitrable. Entering into the issue of arbitrability of the dispute.
My lord.
I don't think Mr. Chatterjee is
He said that.
Never. I have never said that.
Very well. Because I understood that he said that in.
What else will they get into? They will have to decide.
Because section 11, Lord, the arbitrability need not be gone into.
Section 8, because if it is not arbitrable, suit will
go on.
Because it's an exception which is carved out. If the issues are same, then arbitration, or it's covered within the arbitration clause. Otherwise, suit will go on.
So, Lord, I then
Mr. Chatterjee, but
if he does not, then I do not.
I am not for a second.
আচ্ছা তোমার কাছে না না এইটা তুই দেখছিলাম So kindly give me 1 moment.
Yes. Let your junior find out. You can proceed to the next issue because I don't think Mr. Chatterjee is really harping on that.
Not at all.
এগুলো কোথা থেকে বলবো এই ওপরে তো রাখা রয়েছে এইটা এক্সচেঞ্জ অ্যানালাইস আছে paragraphs 27 to 29 sorry 2025 copy আছে তো paragraph 27 to 29 in order to fully appreciate the nuances of the present case, the scope of section 8 of 1996 act is required to be understood. The only comparable provision in the 1996 act is section 11 of the said act, where a reference to arbitration is also contemplated. However, there is a difference in scope between the two sections, which, though subtle, cannot be overlooked. In a Section 11 scenario, the scope of inquiry of the High Court is limited to whether there is a valid arbitration agreement and the dispute is covered by the same. Of course,
There's no dispute. It's well settled. Paragraph 29, it says suit is pending, so it has to be decided whether these issues fall within the scope of the arbitration agreement. I don't think Mr. Chatterjee will be disputing this proposition.
and my lord, another decision Lord, this is on Lord, curability of the defect.
These are not the issues
Well,
because according to his specific case, I don't have that. I cannot produce that.
so that my lord
even
has
if
to be
opportunity is given, he cannot cure the defect.
that my lord has to be tested on the anvil of the
Yes,
pleadings, my
so-
lord, which I indicated to my
So
lord.
it's not that, yes, he failed to produce at that point of time. You are objecting, no, subsequently he cannot. I think then those questions, those issues may have been. Now, his positive case is that I cannot produce that. So I also cannot cure that defect. What is the effect of this proviso, Mr. Chaturvedi?
Lord, kindly see, I am on that, my lord. Provided that where the original arbitration agreement or a certified copy thereof is not available with the party applying for reference to arbitration under subsection 1, and the said agreement or certified copy is retained by the other party to that agreement, then the party so applying shall file such application along with a copy of the arbitration agreement and a petition praying the court to call upon the other party to produce the original arbitration agreement or its duly certified copy before that court. So if he did not had the original document and he had filed, he had a certified copy thereof, then he should have produced the certified copy, not a photocopy of the certified copy. That is not the proviso. The proviso does not say that a photocopy of the certified copy would do. What he has.
No, I think Mr. Chatterjee is trying to draw an analogy with Section 66 of the Evidence Act.
Well,
he says that I do not have the original. I've given you a notice to produce. So he's taking the aid of this proviso with almost identical perimeteria,
Not-
or more or less
not
identical with
applicable.
the language of Section 66.
Not applicable. Why, my lord, I say? Now, kindly see, Lord, what did he, my lord, annex with his petition? If he had
Notarized copy.
a photocopy of the notarized copy, and hence the court said that the copy is insufficient. If it was the original notarized copy, then he could not have had the original notarized copy without having the original copy thereof. Lord, I again come. Lord, there are.
I follow you.
There are, my lord, two scenarios.
According to you, if he has produced the original notarized, then he is having the original document.
Yes.
Otherwise, he could not have had the original notarized copy.
Yes.
And
if he had origin,
he has produced the photocopy of the notarized, that is not admissible as per the proviso.
Yes, because if he had the original notarized copy, then, my lord, he would have had annexed that, and the courts, my lord, would have accepted it in view of the proviso. The courts did not accept it because it was a photocopy of the notarized copy. The courts did not accept because proviso does not permit him to do so. Now today, if he says that I have the original notarized copy, or that I did file the original copy, then my lord, it's a two-edged sword.
Yes.
Then you could not have the original without having the
Anything more?
only this much.
Mr. Chatterjee, my question to you is, you are trying to take the aid of secondary evidence.
Yes.
Please take up Evidence Act section 65 and 66.
Just gives me only 1 minute.
আরেকটা আছে এভিডেন্স অ্যাক্ট আছে? I think you are trying to rely upon this 665 small a. Secondary evidence may be given of the existence, condition, and contents of a document in the following cases, where the original is shown or appears to be in the possession of the power or against such and such legally bound, and when after the notice mentioned in section 66, such person does not produce it. So section 66, if you come to, is rules, secondary evidence of the contents of the documents referred to in 65A shall not be given unless the party proposing. So unless you serve this notice, you cannot give this secondary evidence. This Evidence Act permits secondary evidence to be adduced. Show me from the Arbitration Act, section 8(2), it permits the secondary evidence to be produced or to be relied upon for.
This is the proviso to section.
Proviso says, please see,
forgets about 66. It's a key. I'm not saying, Milord, that your lordship would take it.
Because, only because.
Proviso is there. So now it becomes. Give me a second.
Yes.
I've understood where your lordship is hitting at. What I am trying to say is, Milord, suppose it's not with me. I am saying it's not with me. He is saying it's with me. So it's an issue. It's a dispute which needs to be resolved. It's an issue which needs to be adjudicated. It can't be thrown out saying that since you haven't filed, so it's out. No. And I have, Milord, my learned senior friend loosely said that I haven't filed an application. That's why, Milord, it should not be even looked into. But I have prayed for.
Where is the prayer?
Prayer 37, paragraph 37.
Paragraph
37.
Of the application.
Of the application.
Paragraph of page 37.
I'm sorry, no, 37. Paragraph is 8.
37 paragraph, section 8 application.
Sorry, page 37, para 8. The original development agreement is lying with the plaintiff of the suit, and the plaintiff is called upon to produce the same at the time of hearing of this application. Your petitioner has been in custody of a true photostat copy of the said development agreement containing seal and signature of the respective parties, and a duly attested copy of the said photostat copy of the agreement is filed. However, I'm asking this question to myself, see it from another angle. Why this provision, Milord, is introduced is to find out whether there is any forged document or not. Where the document is an admitted document, I find no joy, Milord, in not producing the original. I'm not out of money if I produce the original.
You are a developer.
I'm a developer.
Who is the expected custodian of a development agreement?
The owner, as well as the developer. There are.
Mr. Chatterjee, what are you saying?
The owner,
how can you perform the duties of the development? How can you obtain the sanction plan without the original with you?
Produced. That part
how
is
could you
gone.
obtain the sanction plan?
But it's nobody's case that it is a presumption that it's with
how
me.
could you obtain? the sanction plan unless you have the original document.
My lord, that part of the
Expected custodian, Mr. Chatterjee.
very well.
of a
Expected
development.
is me, but I am saying I am not.
That's the different thing
Expected.
altogether.
There is no
So,
presumption in law.
developer will be, is the expected custodian
Oh,
of the.
my lord, the application was made in the name of the owner. In the name of the owner. The developer did not pay. So these are all factual things, my lord. There is
Which
no
application was made by
the
the
sanction. Sanction. I am not even praying before your lordship
plan,
going to
Mr.
that.
Chatterjee will be in
Give
the,
me a second. I understand.
in the name of
But
the
I
owner,
bow
signed
down.
by the owner,
I bow
but
down.
applied by the developer.
I bow down.
Because these are the power of attorney
I bow
which
down.
gives him.
Well, I completely bow down. But is this a presumption in law?
That's the
May I
different
ask
thing
this question to
altogether.
myself?
This
Can't
is
be
a-
attributed to every case. Can't be. My lord, here the agreement or whatever is there, my lord, is admitted. My learned senior friend told your lordship that this is admitted document.
Document is admitted.
That's exactly what I'm saying. So that arbitration
What is the
agreement,
necessity, Mr. Chatterjee, of original and the certified copy? In case
because
of
of
a dispute,
authenticity.
in case of a, that could have been in case of a dispute.
I bow
Why
down.
the statute says so?
The statute wanted to find out that there is no forgery. If your lordship goes back to why section 8, this was the requirement is, and many times there can be that there in an somebody might have played around with something. So why it's there?
Those are exceptional circumstances.
I bow down.
But
So
for
here,
that
it's an
exceptional
admitted
circumstances,
document.
statute should not have
If
described that.
it's an admitted document, and if it's the document is admitted, then the arbitration clause is also admitted. That arbitration clause is there, whether it falls within the ambit of the suit, that is the only subject matter which should have been really gone into by the courts below. Now, whether coming back to the first point, whether I have it or not needs to be
According
proved.
to you, that has to be decided.
There has to be an adjudication
On
whether who has it.
how it is to be adjudicated.
Well, there has to be evidence. There has to be evidence led.
Evidence in the suit.
Not in the suit, in the section 8 application.
Yes. Section
In the
8
section 8 application, I'm not saying in the suit.
Yes.
Because here, Miller, this is a disputed question of fact. What is the dispute? Who has it? So that needs to be adjudicated. Because you are throwing me out.
That is why, Mr. Chatterjee, in the Evidence Act, so similar procedure as in 65 and 66. One person is having the original,
Miller,
the other party is saying, no, I don't have the original. I have a Xerox copy, photocopy of
so whether
that.
it is admissible or not?
Yes. So, I'm saying that X, he is having the copy of the original, but this is the Xerox copy. I want to adduce it in evidence. You are objecting, then I will give you a notice. Please produce. If not produced, after that, then Evidence Act gives me a right. Gives me a right to produce that. That will be admitted as a.
Down. Here, this procedure is not.
Here, it's silent.
It's silent. Milord, if it is silent, now
What will happen?
Then what happens? Then the general law will come in. General law of procedure will come in. Milord, it's just
what was the necessity of introducing this proviso? General law was there. General law provided for 65 and 66.
So that is the legislature's wisdom.
Legislature
wanted to curtail.
The legislature wanted Mr. Chatterjee, that is what is troubling me.
What if I don't have? Kindly troubles your lordship to that.
No, that's one thing. I'm on this effect of this proviso vis-a-vis 65 and 66.
Bow down.
So if, according to you, 65 and 66 principles are to be borrowed, then there was no necessity to incorporate the proviso.
I am not for a second saying borrow it completely. Never said that. I said you have to follow the proviso. Milord, in our case, the proviso was not followed. Milord, what happens? Comes back to the proviso once. Comes back to it.
Yes.
Provided when the original arbitration agreement or a certified copy thereof is not available.
The provision.
The provision. Look, I will not take your lordship to a judgment on this. Looks to Milord the provision.
Yes, yes.
Provided that when the Milord, this was entered into inserted in 2015, if I'm not mistaken.
That is what I have said. That is why I told Mr. Chaturvedi that 2008-10 judgments will not be relevant because
judge didn't even look into that. The learned judge, I feel, saw a book which was.
Maybe Mr. Chatterjee, you have produced at the time of hearing book prior to 2015. That happened in Land Reforms Act also.
It happens, Land Reforms Act used to happen early, not now. Used to happen earlier.
No, that or and off
That
was of something. And I tell you that I also, thank God, I also faced the same situation in a Panchayat Act,
Lordship,
23.
that I was aware. Off and on, I'm aware of. What
But
happened
not-
actually, I
At the
understood.
time of argument, nobody
Lord, he
pointed
would
out
have
that.
changed the decision. He had started hearing his lordship. Mr. Raichaudhary was arguing. He had in open court said that the problem.
That is on Land Reforms Act.
On that
I had a
section
problem on Panchayat Act,
It's a
23.
genetic problem.
Section 23.
It's a genetic problem.
No, 23, there is, amendment was there, but the old book was placed at the time of hearing and other.
It happens at times. Only if it's done deliberately, your lordship will know who will do it deliberately.
Most of the time it is.
But
It is,
maybe both of them before the trial courts argued on that, and before the High Court, you are saying this was overlooked. So
I'm
you are
not
blaming,
saying that.
you are blaming, you are not blaming your counterparts,
I'm
Mr.
not
Chatterjee.
blaming
You are
anybody.
blaming
It
the
was on a
court.
lighter note. It was on a lighter note. I'm not blaming anybody. I am trying to say, my lord, that it might be the learned judge did not see the proviso because it doesn't find place in the judgment. My
Because there
learned
are
senior
few-
friends spoken about concurrent facts.
You may be right, Mr. Chatterjee. You may be also right by saying that though in the prayer portion it was not prayed for that,
It's there in
please,
the
it's in the body. But I don't think in the argument you have prayed for that.
Milord,
Please, I have given the notice, no argument in that line.
Milord, if
This
it's
is the
there on
notice to
pleading,
produce, no argument,
Milord,
not a single line.
for that, Milord, the client cannot serve.
Mr. Chatterjee, that's a
That
different
is
part.
where
That's a
Milord,
different part
77 Supreme
altogether.
Court comes into play squarely.
That's a different thing
That-
altogether.
that
But
comes-
it was not argued
Milord, if
by
it had-
any of the
If
parties.
the lawyer doesn't argue on law, for that the
Before
client
both the
doesn't.
courts below.
I bow down. I bow down.
Because this proviso was not
If it's a
referred to,
question of law, I can bring it up before
because
the
this was
Supreme
not
Court.
referred to.
77 Supreme Court, page 5, your lordship knows it better than me.
An argument not reflected in the judgment is deemed not to have been made.
Very well.
Yes, yes, yes.
I can make it before the revisional court.
That's
I can. It's a question of law.
so proviso is
No, no
appears
question
but
of law.
not
Was never
argued by
nowhere.
any of the parties before the
Even
court.
this fact that I have prayed doesn't find place Milord, in any of the judgments.
That might be because formally in the prayer portion it was not that.
The learned
And
judge,
if you take
it
these,
can't say Milord, that the court can't look into pleadings. It's there. So if it's
Mr.
not,
Chatterjee,
it's a
what,
mistake.
Mr. Chatterjee, what happens?
Like-
Usually, yes, yes.
Not
Is
the-
there application prayer?
I
You
have answered-
usually look to the
Does
prayers.
that mean, Milord, I can't bring it up before the revisional court? I can.
That's a different thing.
perversity.
No, that's a different thing
I
altogether.
know that.
Question of law, you can
Milord, I'm
place-
on that. It's
place
a
that.
completely on a question of law which has been overlooked by the courts below. And if it's been overlooked, it is for the revisional court to look into it. 77 Supreme Court, page 5.
No, that's well
It's a
settled. The
question-
facts are already on
It's
record.
on record. And they have overlooked the law. I can. My learned senior friend was, the only argument is, does it shock your lordship's conscience? It should. Because, in my respectful submission, because it overlooks the law completely. Blood consideration of a law and then a judgment on it is one point. Not considering a law, my lord, is something which is perverse. And the courts can't say that I'm not aware of law.
So remand is the alternative.
No, that is up to my lord. My lord, I would say, my lord, your lordship, my lord, decides it here and now. I don't have a problem on that at all. What your lordship would do, my lord, is for my lord, in my respectful submission, my lord, if a law is overlooked, it's perverse and it doesn't need a remand.
If the
Doesn't need a
facts,
remand.
there is no dispute, the
Only
facts are already
place-
on record.
Yes, the only, because that's again Lord Rankin's judgment. The appellate court cannot, and your lordship is a part of the appellate jurisdiction. 70 Supreme Court, page 1. Just reminding your lordship. Now, my lord, what happens here is that if your lordship,
Forgotten, Mr.
no, These judgments, your lordship will never put.
Yes.
But 70 Supreme Court page 1 is a 7 judges bench decision. I was very new, my lord. This is why books should always be. I had the privilege of sitting next to Mr. Raichur. So I was in one matter, I was saying that what a মাথায় এ হচ্ছে এটা কি division jurisdiction টা how far it can go. So he said the only judgment you should read is 70 Supreme Court page 1. And that's, Lord, it's stuck to me for 24 years now. This is why books are more important than anything. So, my lord, if divisional court is a part of the appellate court, that's the first line of that judgment. 7 judges bench. The divisional jurisdiction is a part of the appellate forum of the High Court. And if your lordship finds that the courts have not looked into the law, my lord needs to interfere. Because if your lordship doesn't, saying that it's very easy to say both courts have held one thing, I cannot go. But that's not what it is. Now, how is it relevant with 65 and 66? Your lordship brought in 65 and 66. I would have said that 65, 66 fills in only when, there is a lacuna left behind by the proviso. Where is that lacuna? Is that what happens if there is a dispute? This is not addressed by the proviso. Lord, Arbitration Act is a special statute. So
that is what troubling me, Mr. Chatterjee.
It's
Prior to that proviso, yes.
It is a special.
Prior to the insertion of proviso is one thing.
It's not exhaustive. It's a special statute, but not exhaustive. There are situations which have happened, which is beyond that statute. That it's not exhaustive, there are quite a few decisions on that.
Yes.
Now, especially, in our situation. See, in this proviso, what happens, like Order 22, Rule 4, Sub-Rule 4. If there is a dispute, with respect to who are the heirs. If there is a dispute as to
Order 22, Rule 5.
There needs to be an adjudication. This doesn't take care of that. So what happens is, if there is a dispute which remains unresolved, then Section 8 goes, respectfully submitting, then the entire intention of the entire statute goes. So one lacuna, in one provision takes away, the entire statute, which in my respectful submission is not what the legislature intended. My learned senior friend on merits spoke about the first part of the clause. The second part he did not speak about.
Of which clause?
In any manner.
Of the arbitration clause. Please show me.
Can it looks to 3057.
Yes.
Sees the middle part. I placed it for your lordship's consideration. There is no
manner related there too.
Exactly. There is no answer to that. In any manner related there. So this is something, whether, which goes to the root of whether this creates the arbitrability needed to be considered. The courts only considered, whether this is under the bailment or whether that is this or that, and 8-2 not follow. Even, on arbitrability, there is perversity.
It happened because of both of you.
I'm sure.
Have argued this.
কি করেছি বলো, আমি বুঝতে পারি।
Yes, they have to take the responsibility of whatever has been done by our counterparts in the courts below.
No, they must have argued, well, they are way better than the High Court. But this is what it is. So now, the question is whether Section 8 is taken off completely without even knowing with whom the original is. Suppose tomorrow, the original comes out from him during evidence in the suit. Then what happens? May I ask this question to myself? So for 340, my respectful submission, 340 hoye to arbitration hobe na bhai. My respectful submission is, my respectful submission is there first needs to be an adjudication as to with whom it is. If it is found with him, there will be consequences. If it is found
Anything
with
more?
me, there will be consequences.
Anything more?
Nothing more.
What happened to the development?
There is one thing, Milord, which your Lordship would kindly consider, is that we have serious doubts about the authenticity of that line, of that handwritten line in the written objection. And we've taken instructions, Milord. Earlier we had, it skipped my mind then. We had taken instruction that it's not there.
Mr. Chaturvedi, do you have a copy of that written objection?
Yes. Yeah, আমরা 3.5 পাঠ করে দিয়েছি।
Because,
This is the only copy. This is the only copy.
you had urgency, Mr. Chatterjee. That's why it's
No,
past
because on
3:30.
on Monday also, Milord, your Lordship, Milord, I have to file my written statement.
That is why I
Your
said
Lordship,
that.
that extends.
No, I'm saying that
That just one line has been added after the paragraph.
Lord, I have reasons, Lord, to support whatever is written there.
No,
It's a
definitely.
transcription.
It's not about me supporting or my senior friend supporting. It's about the fact, whether it is there or not. That's it.
according to you, that sentence is not there.
It is not there.
Even if that is not there, he is denying oath versus oath. Because the previous sentence is there.
I bow down.
So, no, previous sentence is also there.
Milord, I am saying,
the
Milord, respectfully,
the defendants have only and the defendant only a photostat copy of the agreement, etc., are out and out false and concocted and baseless. So he has denied your that submission, and he has clarified. And he has clarified that
Milord, I
both of you
can't
can
prove the negative.
no, both of you can take instructions as to
I'll
whether
take that
this
instruction. The thing is, kindly appreciates, I can't prove the negative. That I don't have, Milord, I can't prove. My learned senior friend can prove that by document or whatever that I have the original.
Yes, my lord, page 51. My lord, again, my lord, I, at the risk of repetition, this is not the time, my lord, to address my lord on facts, but the agreement on which he relies kindly comes to page 51. My lord made observations on this, that the developer cannot but have the document in original with him to take steps in accordance with law. Page 51, I address my lord on 9, subclause 5. The owner shall deliver or cause to be delivered to the developer all original deeds relating to the said land simultaneously
what
upon
happened
it.
to the development, Mr. Chatterjee?
How can he ignore this?
What is he talking about?
What happened to the
No,
development?
no, 1 second. Milord, what is he talking about?
He says that the original document is all with
Arey,
you.
we are talking about the development agreement. Vicky,
I say all originals.
arey, all originals relating to the same land.
I am on now who
We
he's
are lost
just a second.
respect to him.
No. He says that the original,
Limit.
please, the original of the title deeds are not with him.
Arey, dhur.
No.
No,
Oh,
he's not,
please.
Mr. Chaturvedi, he's not saying the original title deeds are not with him.
No.
He's saying the original development agreement is not with him.
No, but I have no difficulty in following that. Lord, he says that none of the original documents are with me.
I'm not saying anything of that sort. I am on section A.
If I have misunderstood him,
Chatterjee, why are you getting agitated?
if he's
After all, fighting a case of a client.
yes,
Why are you getting agitated?
Youthful, exuberance.
Correct. That gives him no liberty to disrespect the elders.
Stage, Mr. Chatterjee.
Exuberance.
Malad, I'm not existing.
You have crossed that stage.
No,
Youthful.
age is just a number.
Yes.
It is just a number.
Yes.
We are on section 8. We can't be.
I
talking about identity.
have misunderstood him that he has no documents altogether.
Arey, আমি
Says
সেটাও
that
বলছি না।
with regard to the other documents, he is not saying. He is saying that with regard to the title deed.
Yes.
No.
Title.
Development agreement.
Sorry, the development agreement. I
Since I understood him that he said title deeds also are not with me, so I am replying. If he has not said it,
that's the suit for.
yes. If he is
My
not,
learned senior friend probably, Milord, did not pay, I obviously do not talk very big sense, he did not pay any attention to what I was saying at all.
I was all ears, please.
He said, Milord, I was talking, Milord, nothing with respect to. If I'm talking on section 8, why will I even talk about the title deed? It is non-production of the development agreement which contains the arbitration clause.
Yes,
No question of
What
title
happened
deed.
with the development? Mr. Chairman?
That is not shelved and hence the suit.
Oh, they gave you some. Milord, your lordship wanted that also, if your lordship remembers. to
I'm
take-
asking you what happened with the development.
It hasn't happened.
It hasn't happened, and you are also not interested in developing.
I am, because they are not paying us anything.
Does not appear from the papers. You have also not taken steps
But appears
because
from,
they are
appears from the
papers. From the
from the
papers.
appearance of the lawyer.
No, papers. From
No,
the
no,
papers
I-
because
be very,
no steps taken.
This was on a lighter note. I haven't taken instruction as to what happened, my lord, what is the intention. Because I was only defending his suit. So if he, I can take instructions on that as well.
No, but from the papers it does not say with regard to the development.
Well, I really don't have any instructions on it. So that part also I will answer, because Mr. Chaturvedi made that submission with respect to, my lord, that I have the title deeds. We are not on title deeds at all here.
No, title deeds, that's the
So that
issue in
was
the suit.
that was a
I don't ask you to take instructions and say that whether you have, because that's the main issue in the suit. I will not ask you to disclose your defense here.
So
That's
no, that perfectly. Now, my lord, the question which arises before your lordship is whether, my lord, who has that
so according, Mr. Chatterjee, your simple submission, if it can be put in one line, is that when there is a dispute as to who is in custody of that original document, so that fact has to be adjudicated in connection with an application under Section 8 prior to giving a decision on the
prior
Section 8.
to, my lord, dismissing it.
Prior to giving a decision on Section 8.
No. In our case, it's even better, my lord. It's been dismissed only on that ground.
Yes, so an adjudication ought to have been made
Has to.
with regard to
Then
who is having the.
Especially when, my lord, there is no admission. Here, my lord, if I had admitted that I have the document and even then I did not produce it, then, my lord, the question of, my lord, sending the Section 8 away, my lord, would have come into play. But here, my lord, there is a dispute as to with whom it is. There is no presumption in law, my lord. Since I am the developer, I have the original development.
Is that the expected custody?
That's an expected thing.
I've said,
there is no presumption in
no, I have not used
So
the
if it
expression
comes,
presumption.
That's why I said.
I have used the expression
So if there is
expected
no
custodian.
I bow down. My lord, with respect to that is where presumption comes.
Because everything.
I bow down. I understand completely. But then your lordship would have to presume in law, my lord, it's with. So that's not what the case here is. There can be exceptions to that.
There can be exceptions.
So
You
that-
can rebut that. You can
Absolutely.
say that no, yes, I did not take that, or yes, I took that. I returned it to him. There may be
Many
many cases.
nuances.
So,
Many
but expected custodian is
Yes.
the developer will be having it because
my problem
legal purpose for obtaining any.
is my problem. I cannot prove the negative. I can't prove that I don't have. He has to prove that I have.
He also says he does not have. How can he prove?
He has not said that. He says it's with me.
No, onus lies upon you because you say it's
I
with him.
discharge the onus.
No, you said that it lies with him. It's your positive statement. Section 8 is your application. Onus lies upon him to prove that it is with him.
Now, my lord, the problem here is there's nothing, my
Because
lord, on record.
positive assertion is yours.
No.
And yes, Section 8.
My
you are
positive
saying,
assertion is that there is an arbitration agreement.
which is original is lying with him.
And I'm saying, my lord, that original is not with me.
No. Original is lying with him.
Not with
That's
me.
your positive
With him,
statement.
yes.
That's your positive statement.
Can you see 37 once?
Yes.
I'm saying
In
it's
the
with the plaintiff.
custodian.
The original development agreement is lying with the plaintiff.
Yes.
I'm saying so.
So you positive case, you have to prove.
This is
How can he say he cannot say negative? I do not have.
No.
You have to prove
The
that.
question is, Milord, if it is not with me,
Mr. Chatterjee, but positive thing.
Positive
It's
assertion.
not with, you are saying it's not with me, he is saying it's not with me. Who will prove that?
So we will have,
But
somebody
it's
has
your
to prove
positive
it's with
case.
him.
Mr. Chatterjee,
No,
burden
the
of
same
proof
way
and the
this
onus of
positive
proof.
case that it's with me.
It's your application you want.
Milord, it's the same assertion from him that it's with me.
It's in reply, Mr. Chatterjee.
In opposition.
Yes, in opposition or reply, whatever. So first you make out a case. It's your application. If you fail to prove,
Then we'll have
let
to
us
go back to
let
that.
us assume that he did not appear.
I can't make this simpler. What are we heading to? We are heading towards an authenticity of an agreement.
Mr. Chatterjee, I'm telling you, even by any inquiry evidence, this will not be proved.
If it's not proved, no, then what happens? Me ask this
Yes.
question to myself.
That is,
The arbitration agreement is admitted. The arbitration agreement is admitted.
so on the basis of the photocopy,
On the
it
basis
will have
of
to
the
be-
agreement. On the basis of the agreement, your lordship will send it to arbitration.
Yes, on the basis of the photocopy.
On the basis of the agreement.
So the question is, if there is no dispute with regard to the arbitration agreement, merely on the basis of a copy, Section 8 can be done. That should be the, if there is no dispute is raised.
Milord, if
Merely on the basis of
Eh,
an application.
Milord, if a dispute is there, I'm here on specifically on that there is a dispute. And now in that dispute, has been no adjudication.
No, there is a dispute, not with the existence of the arbitration.
I bow down.
Mr. Chatterjee, let us not go into
Not
those.
going to that.
So let us forget about
So if
all
that
those.
can be used
So
and sent to arbitration.
both of
is
you are
what?
saying, yes, there is an arbitration agreement, and this
But
is the
both of
arbitration
us are
agreement.
saying,
None of you are saying, no, this clause was not
Yes,
there. This
agreed.
clause is here. None of you. So it's an admitted case of an arbitration agreement. So in a case of this nature, there is no requirement to file the original
I am not
agreement.
saying so. I am saying, Milord, your lordship's presumption would be to basically send it to arbitration. When both parties agree that there is an arbitration clause, my lord would only restrict my lord's adjudication to whether the dispute in the suit can be sent to arbitration or not.
Then the Section 8, those
This
provisions become useless,
Milord,
Mr. Chatterjee.
this is a
that,
procedural. This is a procedural law. Filing of the original is a procedural law, which does not override the substantive.
Must be having something.
Must be having something. What? Authenticity. I am saying, my lord, authenticity. Authenticity here is admitted. Now, procedural law will override the substantive law. No. Law is not that. Transport Corporation goes back to those judgments. Procedural law, my lord, is handmaids of justice. What?
Jealous mistress.
Big jargon of that, whatever it is. No, what was the intention of the legislature is to find out the authenticity. Why original? Because authenticity had to be seen.
So it falls, Mr. Chatterjee, when there is no dispute
This is
about
I
the,
see.
what follows is when there is no dispute with regard to any existence of an arbitration agreement,
and
then there is no requirement of the original and the
coupled with there is a dispute as to with whom it is and which requires an adjudication. It's then, my lord, your lordship will use your lordship's powers under Section 8 to transfer it. Because before that, because your lordship, my lord, in my respectful submission, should not or would not dismiss the Section 8 because, my lord, an original document has not been found and parties are not ad idem as to with whom it is. There is nothing on record which would conclusively show, my lord, that it's with me. My lord, in the list of documents which they have filed during the suit, the development agreement is there with the plaint, if I'm not mistaken. Development agreement filed.
You have kindly see your petition. You say that we have not filed it.
না না আপনি ফাইল করেছেন কি আপনার
You have said that I have not filed.
আপনার
That I have not filed it. That is your government.
714টা কোথায় 714টা এই ডকুমেন্ট গুলো ওরা ফাইল করেছে along with the list of documents. Doesn't matter, তোমার কাছে বললে রয়েছে
Page 36. Page 36. Plaintiff deliberately did not file copy of the agreement.
Yes.
That is his case. But
For not inclusion thereof in the list of documents being scheduled B.
yes, yes.
Konta?
Page 36.
Huh?
This answers your
Your positive case is that he has not filed the development agreement.
Then he doesn't require the development agreement back also.
He has not paid for the development agreement back.
He's not paid. So he doesn't require that.
Yes, he doesn't require that. He only wants this tree. Because if he has required that, everything goes. He doesn't require that.
Doesn't require.
Yes.
Because he has it.
Because he doesn't want to enforce that development agreement. It's you who may have an interest to develop.
No,
You may have, because he does not want it to, because his plaint averment said that you have left. It's only at this stage, it's allegation he's frustrated with you. That's as per the plaint averment. So he will not get and ask for a specific performance seeking. Yes, please you develop this.
In possession, may I ask this question?
No, that's a different thing also. But as far the plaint goes, he does not want you to develop his property. That's a different thing altogether.
I'm not even going into
He does not want the property to be
I'm-
developed by you.
Let me, my lord, summarize my submission before your lordship. There is a dispute as to with whom the agreement is in the original. Without deciding that, the application under section 8 could
Would not have been disposed of.
Disposed of.
Or
at all.
dismissed.
Dismissed. At all. Secondly, that's one aspect. The second aspect is
on merit.
Where
it's an arbitrable dispute.
Where you have admitted the existence of the arbitration agreement. And if you have admitted the existence of the arbitration agreement, it can be oral as well. There is a Supreme Court says. When you have admitted the existence of the arbitration agreement, the court should have at least considered whether the dispute which at hand in this suit is arbitrable or not, in view of that clause in that arbitration agreement itself. Any dispute relating to the arbitration, relating to the development.
Where is that? Because if that is dispute, then in that case, the original agreement is not to be produced. Does the Supreme Court say that? If it is not in dispute?
Lord, I have not found a single judgment where there is a dispute with respect to existence of the original. There is
no dispute as to the existence of the original. Yes.
There is not a single judgment on this. It's beyond everybody's comprehension that somebody
Why are
would
you troubling me, Mr. Chairman?
So your lordship would need to decide. This is the first of its kind. There is nothing where, my lord, with whom the original is. Without deciding that, you can decide section.
So you said that if it is admitted, it has to be referred, and if
That's
it
my
is
submission.
no, you said the Supreme Court has said.
No. That's my submission.
another first of
My
its
submission.
kind. Another first of its kind.
Key.
No. Ms. Chatterjee says this case is first of its kind. I say I'm using the word another first of its kind in view of partnership matter, that second appeal. That was again first of its kind. We said that. Both I and Mr. Bose, we said that it is the first of its kind. When Mr. Chatterjee is saying first of its kind. So when he is saying first of its kind, I am using the word another. Another first of its kind. But since my limb of argument is based on the extent of
abatement of a second appeal.
Yes. Partner mara gele pore. Where the suit is filed by the firm, not by the partners.
Acta partner model habit.
There were certain technical facts.
Yes,
there.
yes.
It's not
Yes, yes.
as it
As
is
simple
that
as it is.
as simple as it is. There were
Anything is possible.
because
Nowadays, the Supreme Court is saying
one of the
judgment-
partners, one party claims none of the partners are surviving. What would happen to that?
Yes, yes.
So that's the issue. It's not that out
No,
of
that's-
4, 1 dies, it abates.
Now Supreme Court is saying your specific performance suit is not maintainable if you don't challenge the termination. That was again said differently by another court. Your initial order not looked at. So now where does the High Court go? May I ask this question to myself? Justice Dipankar Datta held that not maintainable. Justice Pardiwala 6 months later says maintainable. Doesn't even look into Justice Datta's job.
Since my limb of argument with regard to the extent of powers to be exercised in under Article 227, only one judgment, if I can formally.
I will not even deny them.
What's the
Whatever.
reference?
Since this is garment craft. Garment craft. Relying on Estrala rubber.
Yes, please give me the reference.
This is 2022, volume 4.
That's his best argument.
That is the only argument.
No, not it's best. In addition, that I will remember when he will be coming for the petition.
Never have I ever argued that 227 is not maintainable.
22, volume 4, SCC,
Now my laws are
page 181.
Page
181.
Against the injunction,
Paragraphs
227s are maintainable.
16 and 17.
227 is a maintainable even against an order of injunction. My lord is hell.
No.
Your lordship has hell. My lord's court has hell. I'll show. Send it to the larger bench, otherwise it's there.
Supreme Court is there.
With injunction. এটা কোথায়?
On injunction, I have delivered a judgment. Whether 227 is maintainable against order 39 rule 1 and 2. Considering Supreme Court.
Your lordship has held it's maintainable. Your lordship has held it's maintainable.
No. 227 not maintainable.
But that judgment says it's maintainable.
I've considered the Supreme Court judgment.
Nah.
I've considered the Supreme Court judgment.
Send it to the line.
No. I've considered the Supreme Court judgment.
Miller, on Monday, Miller, I have to file the written statement by the arrangement.
Mr. Chaturvedi, have you given the copy of the written objection? Have you filed the copy of the written objection?
This is the only copy, Milord.
Please take it back. Please make Xerox copy.
In course of the day.
Give a copy to Mr. Chatterjee and both of you keep a copy with you also.
Milord, what I said, CAV, we will only take instructions on that.
Please take instructions on that.
Inform your lordship on Tuesday or Wednesday.
Instructions on that, both of you.
On Tuesday or Wednesday, whenever your lordship
please inform me on Tuesday. Mr. Chaturvedi, you also please take instructions because there should not be any difference on this. Whether this is the correct fact or.
But Milord, even Milord, bereft of that, Milord, as my lord has rightly.
Chaturvedi, that I have indicated to Mr. Chatterjee, even with those handwritten endorsement.
If it is handwritten, it's false, then serious consequences.
So that's a different thing altogether. And if you say no, it's not the correct copy. There is another correct copy that both of you can give. So,
this is Milord. কোথায় আমরা দিয়ে দিয়েছি
কোথায় ওটা instructions. If you find
instruction is otherwise,
please see ask. If you say it's because Mr. Chaturvedi will also see. I don't think there will be a difference on this. If that is so, then you can give the certified copy. The written objection, Mr. Chaturvedi, please give a copy to Mr. Chatterjee. Please keep a copy with you and give a copy to the
my lord.
The copy.
Instruction. And if we
please
say
take instructions mention. I'm not keeping this.
If it's not there, but keep it to be mentioned. It's better.
Heard No more hearing. So only with regard to that written objection, any clarification, if that is not the correct copy, please give me the correct copy. I don't think there should not be any dispute that which is the correct copy between both of you.
No, no.
Since both of you are here,
Lord, only one small prayer. Lord, could it be, my Lord, at any time before the rising of the first session of the court, instead of in the morning?
why, Mr. Chaturvedi?
My Lord, in the morning, my Lord, I am told, my Lord, there is, my Lord, a matter fixed in courtroom number 11.
তাহলে সময় লাগে।
হ্যাঁ। Is my Lord of that? If it is marked that
Chatterjee, Tuesday you can take 10th.
Or else, my Lord, my learned junior would come, my Lord. Only that much is, my Lord, to be informed to my
Tomorrow,
Lord.
my Lord, the courts are closed. Tomorrow the courts would be closed.
Yes, Monday you will be getting. Tuesday I am keeping.
আচ্ছা রাখো না, ঠিক আছে। No, no.
Tomorrow it's closed. Who says?
কালকে খোলা আছে?
It's closed. So first Saturday, Mr. Chatterjee.
If it is, my Lord, at 1
Tomorrow
o'clock,
is open, so
if it is at 1 o'clock on 11th, no difficulty.
I'm keeping it on Tuesday.
As my Lord pleases.
Tuesday you don't have any
No, no.
difficulty. তাহলে 10th করে দিন। Thank you.